Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Sack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Proctor and Belezos. Ridiculous that insanus. Oy vey, Marcus. Pro said, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know, you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Happy Mega Motion Day to those of you who celebrate. Happy Mega Motion Day. We've been covering this Mega Motion since September. It's been almost a year since Bettero filed his first Mega Motion to dismiss the indictments against Aidan Kearney, and there have been other motions in the meantime. We also have a motion. The O'Keefe's made a motion to intervene to try and get Aidan's phone extraction. I think that's going to be argued today. And what was the other motion? There was one other motion. I don't know. My head's not on straight. It's Monday. It's July 20th. And I'm looking for a mainstream feed. I understand who else is streaming. The only one I'm going to stream is Grant if I can't stream the Zoom, because I also have the Zoom. All right. That's good. Oh, Canton Community TV. That's a good. They have a good equipment. Thank you for that. There's a pool camera of mainstream that it might be Canton Community TV, but I'm not sure. So how's everybody doing today? How's everyone doing? Let's take a look at our motivational quote of the day. Today is Monday, July 20th, 2026. Let's see what the pearls of wisdom are for the day. All right. This is a German proverb for today. Who begins too much accomplishes little. That's a good one. Sometimes you try and do too many things at once and you just can't get anything done. Who begins too much accomplishes little. Maybe I'll get my voice back. Maybe we'll listen to the Zoom so I don't have to talk. How's everybody? Oh, it's Monday. Oh, I almost dumped my iced coffee on the floor. Now, I understand that other channels are streaming with permission. I am not going to stream another channel. If you would like to go to another channel who is streaming it, can feel free to go there. What is not nice is that if you come in my chat and tell people other people are streaming it, so they go watch it there instead. Do you see what I'm saying? Thank you. Let's pull our affirmation for a badass. Oh my. We still have to do a Julie Albert's MSP interview. That's going to be fun. This is exactly what I need to hear today. Here's the affirmation for a badass. Inhale, exhale, and let that effing shit go. There it is. Inhale, exhale, and let that effing stuff go. There it is. Some people needed it. I'm sure I know I did. All right. Mark Bettero did write the mega motion. The first one was initially something like 80 pages. It took us hours to go through. We clicked through all of the hyperlinks. Olivia Nile is involved in the defense team for Aidan Kearney, and she hyperlinked everything for us. It was the first time we had ever seen such a thing. What do you mean in the middle of a motion we can just click on hyperlinks for the things you want us to watch? And we watched every single one of them and read every single one of them. And it took at least 2 shows. I don't remember how many hours it took to get through this mega motion. And there's also a motion that Aidan's team has made to obtain Michael Proctor's phone extraction because of all of the horrific things that Rosemary Scapiccio unleashed, unveiled, and all of the things that were in Karen Reed's new lawsuit of Karen Reed versus the town of Canton and the Massachusetts State Police. And so there is evidence that Michael Proctor was communicating with people to just arrest him, already. Him and Yuri and other people and Tully and all the shenanigans that went on. Remember in front of the grand jury with Tully, where Tully was given clips of Aidan's shows from Kate Peter, maybe they claim, and they were renamed to say such things like their lives are over. I forget exactly what the titles were, but there was an intent folder at the grand jury. And so there are a lot of reasons that Aidan Kearney thinks his indictments should be dismissed. Will the judge rule from the bench today, Judge Belezos? I don't really think so. But each side gets 30 minutes to argue, and we're going to see how it goes. It's going to be Cosgrove versus Betterow with a side of Judge Belezos in there, and it's going to be interesting. I don't think he's going to rule from the bench. I just don't. Alan Jackson made a really great point the other day at Karen Reed's phones. They still have 2 of Karen Reed's phones from January of 2024, trying to get them back, even though they were told to give them back. And then the latest judge, I think it was Doolin, said that the Commonwealth may maintain possession pending appeals. The appeals never happened. And then Alan Jackson went into court last week, I think it was, to try and get Karen's phones back, and made a different argument that Cosgrove should be disqualified. He shouldn't even be on this case because he said at that last hearing, and we went back and watched it, he said, well, Your Honor, I don't know. I need to go talk to DA Marcy, and we need to sit down, and we need to know whether we need to talk about whether we're going to appeal, and we need to talk about, and here's the thing. Cosgrove is a special prosecutor. He was hired because Michael Marcy has a conflict, and he's not supposed to be strategizing and powwowing and in cahoots with Michael Marcy. And so therefore he should not be touching anything having to do with Karen Reed. And similarly, now it's a new argument for why he shouldn't be handling anything related to Aidan Kearney. And here's the other thing is that Cosgrove filed an opposition. The only opposition that it seems that he filed, according to its title, only on Friday. Remember, this was filed originally in September. Usually you have 7 days to file your opposition. So I don't, I guess there's no rules for special prosecutor. He can just do whatever he wants. The only opposition it looked like he filed was an opposition to the release of Michael Proctor's phone extraction. And it is impounded, and he never filed a redacted copy. So we can't see it. We can't see it. So we don't know what it says. So who knows what he's going to argue today, Cosgrove. He may have some whole new theories. It's going to be interesting. I'm going to pop on the Zoom to start. When I go on the Zoom, as you know, I mute myself because there are other newbies and novices on the Zoom who do not know how to mute. And the last thing I want is for my voice to be coming through the Zoom feed because that's happened too many times for me to count. Somebody will be listening to me. They'll be on the Zoom. They don't mute, and it's my voice coming through. So we're going to explore all avenues today. All right. The mega motion is just simply a motion to dismiss. Simply. There's a lot of reasons why it should be dismissed, but we call it the mega motion because it was so big. All right. So let's see if we can get into the Zoom. Hmm. Hmm. I don't know. That doesn't look right to me. Is anybody on the Zoom? And if you're on the Zoom, I'm not on mute. What are you talking about? Who said they can't hear me? Oh man, if the trolls are going to start this early, I don't know if we're going to make it. It is a mega motion. Kindergarten. Kindergarten. Everyone smash the like button. Smash the like button. Herder of cats. Thanks for your 10. Let's go. Free the turtle. It's times like these. I love the time difference. It's going to be a long night in Australia. Love you. Love you too. Jamie in Gilead says, oh my God, I started listening to the police interviews and I've gotten so used to or addicted, I don't know which, to your narrations that your voice has become the little voice I hear when I see crap that makes my head pop off. That's hilarious. That's hilarious. That's very funny. Thank you, Jamie, so much for your 20. I like your picture. Tara says, Tasha, I'm sorry, it's Monday. One more day until I find out the gender of my baby. Oh, that's so exciting. How exciting. Congratulations. Let's start this week off right with some justice for free speech. I agree. It is too easy for the trolls to ruin the Zoom feeds. And yeah, I mean, some people, I guess it would be intentional. I don't really know. I don't know why people do the things they do. I've given up trying to even figure it out. But Grant Smith Ellis is also in the courtroom. He said we could use his feed, so we will do that. We will do that if we can't find a mainstream camera with good audio and video. Welcome, Jen Fisher. Thanks for becoming a member. Thanks on top for your super sticker. Buzzing for Truth. Hello. Hello to you too. Thanks for being here for 25 months. Brown Eyes, go, TB, go. Kel says, I love you with all my heart. Love you too, Kel. Thanks for being here. Jem says, everyone loves Mondays with Melanie. Oh, thank you. Good morning. And look at this. Look at Robert B coming in here and gifting 10 memberships. Thank you, Robert B. That's a very sweet way for you to start off our Monday morning. And for those of you who were randomly gifted, welcome. All right, hang on. It's hard to talk to you and juggle all of these things at once, but I do what I can without a full staff. Hold on. Thank you, Robert B. I really appreciate it. Cheapy's here. Cheapy is a postal carrier and loves the channel. Plus, my kid turned 3 yesterday. Congratulations. Happy birthday to your child. And there's a lot of mail carriers that watch the channel. So you guys are doing the Lord's work in all weather. So thank you for that. Music to My Soul says there better not be a hot bench with a 30-minute time limit. There is a 30-minute time limit. It's in the order. Also, Lindsay Clancy's case is starting jury selection today. And I don't know who's televising that. I don't know if Law and Crime has it because they're not putting their feeds up until like the very last minute all of a sudden. So it's kind of weird. But they're just starting jury selection. Usually the judge comes in, talks to the panel. So we will see. Grant hasn't started yet, but I'll put him up for now so that you guys know. And I'm going to just make a phone call behind the scenes. So let us just, Grant's going to be coming on the channel tomorrow at noon. We're going to be doing a collab. That's Grant Smith Ellis. For those of you who don't know, we're just going to wait for it to start. But in the meantime, I need to just get off and make a call and see if they change the Zoom. Oh, please. Talk amongst yourselves. Talk amongst yourselves. Okay. I thought I shut my camera off. I guess I didn't. I have the correct Zoom, so we're good. Music to my soul says there better not be a hot bench with a 30-minute time limit. There is a 30-minute time limit. That's exactly what there is. There was an order that we went over the other day, all about that. And so we will see. Oh, evidence over emotion. My crystal ball is broken. However, I have no idea. I don't think he's going to rule from the bench. He's going to take it under advisement. That is my guess. And I don't know what's going to happen. You and I. It's starting. It's starting. Nice, right?
You haven't registered with the SJC. Per the SJC rule 1.19, rebroadcast is inappropriate and unlawful. So,
Your Honor, I'm
1.19, rebroadcast is inappropriate and unlawful. So,
Your Honor, I'm happy to go through in the order that you set forth in your order.
Sure.
I have had some discussions with counsel on some of the issues, and I don't know if you prefer to hear that first.
that's on the discovery issue.
Yes.
All right, we'll come to that last. If you've reached a resolution, that's fantastic, but let's deal with the motion to dismiss first. Mr. Bedrow, your motion, I'll hear you. You might want to concentrate on a couple of things to start with. Number one, there was already a fully litigated motion to dismiss both under McCarthy and under Odell, in which Judge Doolin drafted a 36 or 37-page a decision, which is an exceptionally fulsome decision from the court, in which he found probable cause for the majority of the indictments, but dismissed all of them, including the one that seems to be at the heart of a number of these motions, that is to say, against Mr. Proctor. So the first issue is this: under Rule 13, under Commonwealth versus De Los Santos, which I'm sure you've reviewed, which is 492 Mass 242, 2023 case. If the matter was not raised, it's considered waived. So tell me why. I understand that the issues with Ms. Peters may have been disclosed post that hearing, at least to some extent. Tell me why the other issues are waived under De Los Santos and Rule 13.
Was there another issue you wanted to focus on as well?
No, that's to start. Then we'll get to the substance of it.
Thank you, Your Honor. Judge, it is true that many of these issues existed in grand jury transcript and motions that were ruled upon by Judge Dewey. That is correct. And Rule 13 does state what it states, but there is case law which also states that the court does have the power to reconsider or reevaluate issues which were not brought to the court's attention. Now, in this particular case, there's no question that issues that related to the wiretapping, the uncharged wiretapping, for example, could have been raised. As the issues related to some of the videos in this case, the name changes, the court should be aware that for whatever reason, that snuck by everybody, including Judge Doolin, including Mr. Cosgrove and some of his filings. And as soon as that was picked up, that is something that we put into writing and addressed right away. The reality is the grand jury in this case was not proper. I mean, I think, and I'll get to that in a minute after answering Your Honor's question about the waiver issue, but in terms of the form over substance.
It's not really form over substance. It's substantive. Rule 13 is substantive. Del Santo is substantive. And there's a reason for that. And the Commonwealth and our opposition has pointed it out. So you can't keep retelling the same ground over and over and over. It's not going to get go forward. So it's not just form over substance. So you got to give me a little bit more than that.
Well, Haskell permits it, Judge.
It does at the court's discretion.
Right.
But you got to have a reason.
Absolutely, there is discretion of the court to ultimately decide what should be done and what shouldn't. But where the court sees, again, with the videos that were mislabeled, the Commonwealth shouldn't benefit from what is clearly deceptive conduct in terms of renaming items that, again, nobody saw. Judge Doolin himself referred to the names by their improper name during his ruling.
Which presumes that Judge Doolin was aware of those names and didn't find them to be of any substance because he watched the actual videos.
I don't know. Well, the actual videos that were presented to the grand jury, Your Honor, were 40-second snippets of hours-long video, which were not grand jury exhibits. So respectfully, there's no way that Judge Doolin could have watched those videos because Mr. Mello and
you watched the clips, no doubt.
yes, but the clips are tiny segments of larger videos that, again, when we get to the real meat of what I want to discuss with the court, would show the full context on the critical issue in this case, which is only one, and that's Mr. Kearney's intent. That's the only issue that was really before the grand jury, and none of that was seen in Judge Doolin's opinion because none of that was before.
Because it wasn't raised.
Well, it wasn't raised, but it wasn't known by anyone. Now, again, could it have been? Yes, but the court has the discretion.
But it was known because Judge Doolin referred to it by the titles that you think are inflammatory.
Yes, those are the names that he was provided by the Commonwealth that were changed. Those were the improper names. Names that the Commonwealth knew in advance were not the proper names and were changed. And ultimately, Your Honor, as a matter of discretion, there's no prejudice to the Commonwealth here by having this. I suspect this argument, which is a fair argument to make, is their primary argument because they don't want to talk about what actually occurred in the grand jury. And the fact of the matter is, everybody sees it, everybody knows what it is, and it ought to be addressed. If there's no prejudice to the Commonwealth, the court should hear it. No indictment should be tolerated when it is rife with misleading evidence, distorted evidence, statements of prosecutors and police witnesses saying, in my opinion, it was this man's intent to commit witness intimidation. That's outrageous behavior in front of a grand jury. And when you get down to brass tacks in this case, that's all that this is about. They misled the grand jury on the only issue that matters, which is whether Mr. Kearney's intent was to commit witness intimidation or not. The conduct at issue is open and shut. It's the videos, not the videos that were submitted into the grand jury. Those are tiny snippets. The conduct and the context of Mr. Kearney's intent are contained in the actual videos. And what you have at this point is very similar to Odell itself. In essence, you have prosecutors cherry picking 30 seconds they like out of a 2-hour video and saying this proves his intent was to intimidate witnesses, but not letting the grand jury have access to the other 2 hours, which show him saying, I want to bring awareness to a miscarriage of justice involving Karen Reed. I'm petitioning the government to address that. I believe that these police officers are corrupt. We're doing this to bring justice for these people. The grand jury had a right to that. And the best example of this, Your Honor, to get a full picture of what you're dealing with is all of the picketing counts in this case are from this so-called rolling rally. That entire video, the whole rally was video recorded by Mr. Kearney, literally the crime, if you will. They didn't introduce that video, but what they did do was admit 58 seconds of the rolling rally, which the honest name of that video on YouTube was Canton, the rolling rally, Justice for Karen Reed and John O'Keefe. They took 58 seconds of that video. They introduced it as, the title of that video is Don't Feel Sorry for the O'Keefes. That's not evidence, but if you look at the grand jury testimony and the transcript, the way Mello and Tully did this is Tully said, the name of the video is Don't Feel Sorry for the O'Keefes. It's contained in a folder literally titled Intent. Literally. And he did that approximately 30 times throughout this proceeding. Told the grand jury, this is proof of his intent. They literally asked questions and answers that talked about intent. They played 30 to 50 seconds of this video where he literally says, don't feel bad for the O'Keefes, but yet don't present the video of the crime. Why? What prosecutor?
But their allegation is that he's the crime.
Your Honor, again, it goes to Odell, literally. They can believe anything they want. They can allege anything they want.
But they're not alleging that the rest of the rally was intimidation. They're alleging those clips.
Of course.
Intimidation.
Right, but Your Honor, when they present it to the grand jury, it's tantamount to what happened in Odell with the police report, where we decide we like sentence 1 because we think it proves his intent, but we don't like sentences 2, 3, 4, and 5, so we're just going to keep that from the grand jury. In Odell, that was deemed to have impaired the integrity of.
The police report and the video are very different things. We often encounter situations at the grand jury where they have hours and hours of videotape, but they only play certain clips.
But they didn't tell the grand jury it's available for you. The point is, they told the grand jury the name of the video is, Jury Influence is another one, which was actually titled Protesting Michael Morrissey. Big difference. A video that was 5 days after DA Morrissey made a statement to the press, which was improper. He gives a 2-hour video and says, I'm trying to bring awareness, trying to do this and do that. And this is in August of 2023, well before a trial. And says, absolutely, I want to influence the public and the jury pool. And they take that little snippet. They may have a theory that enables them to say, we believe that's proof of his intent. That's fine. What's not permissible, though, is to rig it in the following way, to say, literally, Your Honor, I can read to you there's a literal question and answer, which is very important. For example, on December 19th, question from Mello to Tully, before he plays all of these videos, which are misnamed, cherry-picked, do you have any knowledge of incidents which you feel are intimidating of a witness with respect to any particular witness? I do. Question, those are on video. Answer, they are. Play those for the grand jury. So now we've just told the grand jury, I think his intent was to intimidate witnesses. Then what Tully does again and again through direct intentional questioning of Mello, it's not volunteer, is to say that these videos are named inaccurately, and they're in the memo. You've seen them, page 62 and 63 of the motion, all the times that they did this. They play the snippet, and then when it's over, they tell, or before they do it, they tell the grand jury, these are from a folder marked intent. He didn't do that.
So, you have to give the grand jury some credit. The grand jury understands that a defendant is not going to create a folder which says intent. They had to know the prosecution created that.
That's my.
Okay, stop. He's giving the grand jury way too much credit. Way too much credit. Okay? Juries don't even understand what reasonable doubt is. You think they understand that it wasn't really labeled intent? That's a ridiculous argument. Juries believe what they are told, grand juries. Okay? They believe that the prosecutor, because remember, there's no defense attorney in a grand jury. There's no defendant. It is just the prosecutor and the witnesses and the grand jury. There are no rules. They can do whatever the hell they want. They're going to trust what the prosecutor is telling them is the truth. And when they are intentionally deceptive to the grand jury, that's a problem. This judge doesn't seem to see it. We'll see how it goes, but so far it's not going well.
Right, but give the grand jury some credit. They understand that.
Your Honor, the point is, respectfully, when a police officer tells the grand jury, in my opinion, this man's intent was this. I have a folder with proof of his intent. It came from that folder. I'm going to tell you a false name of the video that I renamed or some third party working with him renamed, whichever the case may be. And then you don't tell the grand jury that this was renamed by us, put in this folder by us.
Can you not hear the video? Thanks to South of History, but can you not hear it, the audio? Because I can hear it just fine. Does anybody, do I need to boost it more? Luckily, it's Grant's feed, so we can boost it as much as we need, but everyone said it, that the audio is fine. Thank you for your 5. Can you hear it fine? Okay, fine. Everyone go over and give Grant Smith Ellis a like and a sub for doing the Lord's work and letting me stream his actual feed. He's sitting in the courtroom streaming this. Send him some lunch money if you feel so inclined. He will be on the show tomorrow at noon. Okay, thank you.
I'm playing you 30 seconds, but I'm not going to give you the rest of the video. And I would refer the court, this case is cited in the memo of law that went with the motion completely, the appeals court case, not the SJC, the lower appeals court, where they cherry-picked a portion of a statement of a defendant, left the full flash drive in front of the grand jury, but never alerted them to the contents of it. And in that case, the appeals court found it impaired the integrity by hiding the ball. Here,
You're going to go there. Mr. Better, if you're going to go there, then you got to talk to me about Shaquille Brown, which is the SJC, in which the prosecutor dumped in at least 100 pages of prison records, in which the prosecutor dropped in telephone logs, all of which had never been looked at or never been read. And the SJC said, well, it wasn't so good, but that's okay because it didn't change the analysis of the evidence, which takes us back. And this is the difficulty.
yes, sir.
So this is the difficulty that you have. See, this is why Dos Santos does matter, and it is substantive. Okay, this is why Rule 13 is substantive, because you already had a very thoughtful, all right, a bulwark, if you will, from a judge, all right, a very thoughtful judge who examined in detail the entirety of the grand jury, found it to be free from prejudice, and more importantly, found that the evidence was substantial enough to issue an indictment. So that brings us back to the court's analysis in Shaquille Brown, which I'll give you the side if you like.
I have
490, 171, and I'm very familiar with that case. All right. In that case, the court finds clearly they shouldn't have done any of those things, but finds it didn't impair the integrity of the grand jury, which does, and this is why Delasanto is substantive. Because Judge Doolin's already made that determination. So you got to get around that.
I'm happy to, Your Honor. The difference with Shaquille Brown and Judge Doolin's decision and why it matters here is context is everything in terms of his intent. Oh, he is.
But in Brown, they're trying to show joint venture, and they dump in prison records they haven't even read.
Judge, I'm bringing it to this case, okay?
But this is the SJC telling us.
I understand that, but the facts here matter and the context matters. And just because the prosecution has, a one sentence explanation of what they say and a grand jury ultimately determined was proof of intent after they were told what his intent was by the prosecutor, by all the reasons that we spoke about earlier, context is everything. If there is a long statement that was talking about protesting and bringing awareness and making jokes and all kinds of things, and there's a comment in there that I like that comment, just give the grand jury the whole thing. The role of the grand jury is fact finder. The problem in this case is that Mello and Tully decided to be prosecutor, detective, and fact finder.
Grand jury's not really fact finder. Grand jury is more of a gatekeeper. But go on.
But they have to judge respectfully.
Grand jury is more of a gatekeeper. The old saying is a good prosecutor can get a grand jury to indict a ham sandwich for exactly the reasons that I just told you. And this judge is saying, yeah, the grand jury is just a gatekeeper. They all indict. They didn't indict Karen and Aidan for conspiracy to commit witness intimidation. Remember that. I don't like the way this judge is, I don't like where he's going, and I don't like that he's trying to out smart Betterow with his knowledge of the case law, but Betterow knows the case law too. Taking it back a sentence.
The grand jury is fact finder. The problem in this case is that Mello and Tully decided to be prosecutor, detective, and fact finder.
Grand jury's not really fact finder. Grand jury is more of a gatekeeper. But go on.
But they have to judge respectfully. They're not. They have to find the facts to support an indictment. And in this case, they literally did, but they were misled. And context matters. A grand jury is entitled not to everything in the world. It's clearly not a trial jury. We all understand that. But when you do it, you have to do it fairly. And they put their finger on the scales with evidence of his intent in terms of what they told the grand jury, what file it was in, the length of the video, the full context of the video, the uncharged crimes. Judge, the last piece of evidence in this case that they put in the grand jury was an uncharged crime of, again, the rolling rally video, which they didn't see fit to give the grand jury, which makes no sense. If anyone's prosecuted these cases and put in cases in the grand jury, that makes no sense. That's the crime. Give it to them. But what they did was they tried to suggest that he was harassing and intimidating the O'Keefe. So we're not even charged victims in this case. That's how they finished the grand jury. That is clearly a design to prejudice, to smear. They put in evidence of an uncharged wiretapping and read the statute that said this is punishable by 5 years and never gave a curative instruction, never withdrew that charge. De Los Santos or not, Your Honor, the question is, at what point do we not avert our eyes to what they did? They need to do it fairly.
But the judge has already looked at that.
But he didn't see that, Judge. If you look at Judge Doolin's decision, none of that is addressed because he, like everyone else, was misled. Moreover, Judge, I am focused on the grand jury. I'm going to answer the questions that obviously you're focused on. There was a second component to the motion for extreme government misconduct, and there's no reason why.
Well, I'll listen to you on the Peters stuff. I mean, I think if Peters wasn't known to you, I think that's fair to discuss.
Well, it wasn't. The whole point, but before I get to the merits of that motion would have been made anyway. So that, I mean, because we can't make a motion based on evidence of which we're unaware, obviously. And at that point, if you're making a motion to dismiss for extreme government misconduct, there's no reason why the court should not consider as a facet of the misconduct that occurred in this case what occurred in the grand jury before. Now, as far as the Peter stuff, which I don't want to beat to death, and most of it is in the papers, the point is all of that evidence should have been disclosed in early 2024, which was the, we're closing the deadline for discovery. That material didn't come anywhere near that timeline. It came in July of 2025 after numerous specific, very specific Brady demands and Discovery Rule 14 demands. They could not have been more specific.
So let me understand, what is the basis that you're asking me to dismiss? Is it discovery violations or for the subsequent violations?
Well, it's for everything. On the second component of the motion, the indictments ought to be dismissed based on the impairment of the integrity of the grand jury proceeding, full stop. As far as the second component, based upon the lack of discovery, that prejudiced us from filing a full-throated motion the first time. The court should consider that in even hearing the grand jury component of it. But in any event, if the court is wondering why discovery was ordered to be completed in early 2024 and all these demands were made before, during, and after that time period, and stuff that is responsive is showing up in July of 2025 that we turn out to learn was in the possession of every single prosecutor on these cases in December of 2024, which is before the motion was filed in front of Judge Doolin. What is going on?
I consider these to be two separate categories. That's why I started with the issue of Peter's maybe something which is outside Rule 13 of the De Los Santos analysis. Just want to give you an open field to discuss that.
Okay.
Before he starts, it's Peter. Peter. It's not Peters. It's Peter. All right. Beto needs a drink. He needs a little water break. The judge is not very friendly. It's not really going our way right now. Let's see if he can be a little more persuaded by the fact that Kate Peter was a not so confidential informant working with Tully to trap Aidan and conspiring with Ken Mello and Brian Tully and Kate Peter to get Aidan incarcerated and relabeling all of those videos. Let's see if that will persuade this judge. My hopes are not high.
Excuse me, Judge. The evidence that exists or no longer exists from the third party that the court mentioned is extremely prejudicial to the defense. There is a strong argument that could be put forth if there were to be a trial in this case that this investigation was biased, it was shoddy, and that involves any number of things, one of which includes, from our perspective, which is a shockingly close relationship between a private civilian, Peter, who you mentioned, who has a hatred of Mr. Kearney that is beyond adjectives that I could even provide this court with. Not only that, this is a witness who has falsified evidence against him. Literally, this is not in dispute, it's in the motion, has forged court filings to try to screw him in part of their fighting during their lives, has attacked witnesses for the Commonwealth, Alberts, and tried to get him to say bad things about them when she in fact defamed them. And this person was basically holding Mr. Mello's hand. These are the messages that we got, amongst other things, telling him what to do. And when we got that affidavit from Tully, oh, well, I didn't open or click on any of these links. That's a problem for one reason, because they were in their possession, custody, and control, and ought to have been turned over. And what was contained, we don't know. But there has to be under Neal a reasonable basis to believe there might be something useful. And the reasonable basis you have is that the person who provided it to Tully that he claims he never opened has committed forgery, fraud, deception, and crimes against him. She's a dishonest person who is working hand in hand with the prosecutors in this case. Now, Tully says, I never opened it, and now the links are gone, and we were told in filings, it's been dismissed, it's been deleted by a third party, which presumably is Peter, and what are we supposed to do in now finding the evidence to support that defense? Just assume it's nothing helpful? Why would we assume that when this woman is bent on destroying him and commits fraud? What's that?
Isn't the shoddy work that he never opened?
That's amongst other things, but I said to you, Tully said that. That's not what Mello did. The emails that we got too late in the process literally show Mello and Peter talking, and he's asking her help. How do I open this? And Mello says, gee, thanks. He literally opened it. Opened what? Where is it? Tully says, I never opened it. It's deleted. Mello, very noticeably, never submitted in all the time the prosecution had to respond to the motion, and if the court remembers, they got many graces and deadline extensions to file, never submitted a sworn statement explaining any of this. What we got instead was a hearsay statement where Mr. Cosgrove, and I say this with due respect to Mr. Cosgrove, was essentially cosplaying as Mello, saying, this is what it would be. That's not evidence in response. What was required is something from Mello under oath, and we've never gotten that. And that's very important too, Your Honor. One of the things that we asked for in the motion is, as an alternative, a hearing. Okay? If this was intentional, the court should factor that in. Now, how can the court make a finding whether this was intentional or not without hearing from Mello, Tully, Peter, anyone else who may or may not be involved in this?
Yeah, let's have an evidentiary hearing, Judge. How about that? They do that in a lot of places, apparently not there. Lally's going back on the stand in August. Here's the other thing. Remember when Cosgrove wrote that opposition and he said, now I'm going to speak to you in the voice of Ken Mello, because if Ken Mello would speak to you, here's what he would say. And Ken Mello didn't sign it. And then Cosgrove proceeded to speak during part of his papers in the voice of Ken Mello. It was the most bizarre thing I've ever seen and that you have seen, and we laughed about it for a long time. And it's inappropriate. Mello needs to come in and get under oath. Tully needs to come in and get under oath. Kate Peter needs to come in and get under oath and answer your questions, Judge. How about that? Ridiculous.
Is this affecting major representation?
Well, Peter,
I just want to see the argument. I'm not.
as far as the grand jury goes, it's either Tully or Peter who renamed these files. Now, Tully knew the full name of the files.
But according to Tully, he doesn't open. So I'm just trying to. You may have a separate argument. I'm not saying you don't.
He's really like hanging on the fact that Tully says he didn't click on Kate Peters' links. Tully doesn't open links that he doesn't know where they came from. That's what he says in an affidavit, maybe. How about get him on the stand, Judge? Why do we believe everything? Tully's fingers are in everything. Tully's going down. We all know it.
Okay, as to what the relation between Mello and Peter was or was not. I'm just trying to make sure I understand your argument. Is this part of the Odell or is this some separate motion?
Well, on some level, it's a hybrid. I mean, there's clearly the Odell component.
I gotta understand what that hybrid is,
Right.
Council.
No,
You become a mismatch here with all sorts of stuff in it, and I'm trying to sort it out.
Judge, there's a standalone Odell motion, clearly, about impairing the integrity of grand jury proceeding. We also filed.
But how does go on, I'm listening.
There is a second motion to dismiss for extreme and egregious government misconduct based upon.
I need to meet with a separate motion to dismiss based on what you filed.
No, Judge, it's a second point.
All right, this is the problem with your filed. We'll discuss that already. I can't discern that there's a second motion to dismiss here. It looks like a big old bill.
Judge, we don't know what missing evidence we didn't get. And the argument that was put forth in Mr. Cosgrove's response to this was that if you don't know, then there's no obligation for us to turn it over because there's no reasonable possibility to conclude that it would be favorable to you. And the point is, when it's evidence that was deleted, that was reviewed by Mello, Tully claims he didn't, and it comes from a source who hates him and commits acts of fraud and forgery against him, there's a reasonable basis to believe that something wasn't right in that evidence. We don't know. And this woman was assisting these people back right before literally days before the grand jury, explaining to Mello how to use the evidence. What is that evidence? She sent a folder titled Intent. That may we don't know, but that may very well be the clips, the change names. She'll probably deny it. She'll go online and deny it and scream and yell about it. Tully says, I never looked at it. Mello is unheard of. He just disappeared in the wind. Let's get to the bottom of it.
Yeah.
Let me get a better motion than what I got. Mr. Cosmo, what do you tell me?
Hold on a second. What did he just say? I need a better motion. Look at his hand on his head. This judge is like every one of us right now. He's going to let Cosgrove speak, but before he does that, what the hell did he just say? I'm going to need a better motion than that? Hold on.
These people at a minimum should be called in, take oaths, and let's get to the bottom of it.
Let me get a better motion than what I got. Mr. Cosmo, what do you tell me?
So it sounded like to me. Here comes Cosgrove.
I want me to just go through it, it's right.
Sure, we just need to support.
Okay.
Oh no, go to the podium. Go to the podium, geezer. Get to the podium. Don't just stand up with your back to everyone. I'm gonna have to boost this more if we can't hear him. So give me a break.
First, whenever I hear counsel use the word cherry-picked, what that means to me is the Commonwealth picked relevant evidence to support the charges it was looking for. I don't have any real answer. I don't deny that that was what, in this case, Mr. Kearney said, and did, and put on the air.
Why not give them the whole video?
I'm sorry.
Why not give them the whole video? So go to Mr. Devereaux's point. Why not give them the whole video to watch and play them selected so this is off of the case?
Is this boosting enough? He's like, why don't you give him the whole video? Why don't you give the whole video? Why didn't you let the grand jury watch the whole video? Can you hear it okay? Boosted it pretty high. The judge is a little bit lower than Cosgrove, but as long as you can hear it, let me know. No, I'm not going to speed him up to 1.5. We got what we got. All right, you can hear fine? Okay, here we go.
I don't know what the reasoning was at the time, Your Honor, but if you look at the chart that Mr. Devereaux includes in his motion, his affidavit rather, it runs on for about 3 pages. There's lots of videos. They tend to go about 2.5 hours each. If we give them the whole video, there is lots of other material in there that language used by Mr. Kearney, whatever, it could be construed as prejudicial. I'm sure Your Honor has already heard about reference to the O'Keefes, and the Commonwealth introduced this, and then they didn't indict him with respect to intimidation and the O'Keefes, and this was entirely inappropriate, et cetera, et cetera. I'm sure if Mr. Mello had put in 25 whole videos, we'd be getting an argument that all kinds of prejudicial material was put in. And
Hold on. You're trying to indict a man on 16 felonies that carry something like up to 10 years in jail each. So you're trying to put him away for 160 years, and you don't want to spend the time at the grand jury letting them watch all the videos when you're trying to put a man away for that long for things that are protected under the First Amendment, based on information that you're getting from a woman who has made it her life's mission to destroy this man and who has submitted false documents, a false federal lawsuit to YouTube to try and take his channel down? Really, that's what we're doing here? You didn't want the grand jury hearing his language, and you didn't want them to spend so much time watching all the videos? Okay, got it. Got it. You see what's happening here?
So the Commonwealth should have simply chosen what was relevant to the indictments. I have to say, where's the beef? I keep hearing about stuff being taken out of context.
Where's
If
the
only
beef?
there was the context, if only the whole thing had been shown. The defense has read my response. It said, Your Honor, and one of the things I said was, where is it? Where's the submission to the court? These are the things that if only the grand jury had viewed them, as Your Honor is now capable of viewing them because we have submitted them, and certainly Mr. Kearney has access to his own video, he would have put things in a completely different light, and here's why. You don't have any of that. There may be some things in the entire videos that for example, Mr. Belezos says at one point Mr. Kearney talks about how he's going to expose corruption or something like that.
Yeah, that's exactly what he's trying to do. Expose corruption. Look how Cosgrove thinks it's so ridiculous that there's corruption in his home state of Massachusetts. Like, oh, he's trying to just expose corruption or something like that. Bradle sat back in his chair. He's like Charlie DeLoach, the foreman from Karen Reed's second jury. He's like, oh, I see how this is gonna go. Okay, I'm just gonna put my pen down, and I guess we're going to trial on this, right? Here's Charlie. Sometimes we have to put Charlie in the corner.
Mr. Kearney talks about how he's going to expose corruption or something like that.
Something like that.
Mr. Kearney could have 16 different motives. People have more than one reason for doing things, for putting something in. Some of those motives may be good motives. But those motives are irrelevant. All the Commonwealth has to prove is that one of his motives was to intimidate those witnesses. That's what's relevant. Furthermore, I think, as your Honor alluded to, we can infer a certain degree of sophistication on the part of the grand jury. Nobody watches even the evening news and sees a snippet of a Trump press conference or something going on in the city of Boston or an excerpt from what's going on in court and leaves under the delusion that other things weren't said, other things weren't happening. They understand that the news media selected what they considered relevant and showed that.
Yeah, like when the news media reported that there was ring camera footage of Karen Reed hitting John O'Keefe with her car. How did that work out, Cosgrove? You're comparing a snippet of something that the president says on mainstream media to trying to put a man away for 160 years? Nobody watches mainstream media anymore, Boomer. That's wild. That's a wild comparison.
I think that's what Mr. Kearney does on his own broadcasts.
Hey.
People sophisticated based on years of watching news shows and years of, at this point, watching the internet. There's nothing to stop a member of the grand jury, and for each of these witnesses, grand jurors have an opportunity to ask questions, and if you've read the grand jury transcripts, you know they did ask questions, and they certainly could have said, you know, you're only showing us a snippet here, we'd like to see the whole video.
Right.
Nobody did that. Nobody.
We didn't put this on the grand jury to make sure that he has a clear presentation.
No, I don't think we're putting it on the grand jury. I'm simply pointing out that in addition to the other points I've made, the opportunity was there. Nothing was being concealed. I think the practicalities of presenting the grand jury with however many hours it would have been, 26, 46, however, these shows of Mr. Kearney's run about 2.5 hours. would be somewhat absurd, frankly. I think the Commonwealth's obligation was to show what was relevant, and that was what we did.
Tell me about the issue, your thoughts on the issue, Ms. Peters and Mr. Miller.
All right.
Peters and Tully. He thinks grand juries are sophisticated enough to know that they can ask questions and they can ask to see the whole video presentation. And, you know, he didn't want to keep them that, or Mello didn't want to keep them that long. So it was perfectly acceptable to show a 30-second clip from a 3-hour video where if you watch what he said around it, a lot of that times what they're saying that he said is totally misconstrued. Petitioning activity, trying to get the public interested in Karen Reed's innocence and showing all of the sus behavior by all of these people who he's in charge with, intimidating. And by the way, don't forget that Jen McCabe sent Aidan like a semi-nude picture of a man in July of 2023 after she was visited by the FBI before he ever reported on the case. Okay. Let's let Cosgrove now tell us about what he thinks about the relationship between Tully and Kate Peter, because it sounds like the judge thinks that's the better argument.
Tell me about the issue, your thoughts on the issue, Ms. Peters and Mr. Miller.
All right. With respect to Ms. Peters, I want to make a couple of points. One is Mr. Federer raises this issue of the prior federal court suit, which Ms. Peters apparently admitted to having forged a document or something of that nature. Well, Mr. Kearney would be aware of that because he was involved in it. But there was no reason.
That has to do with Kate Peter forging a federal complaint, a copyright infringement complaint that she stole off the internet. She did a scratch and sniff, changing the names and throughout the caption and the dates, but forgot to change the index number, which was an index number that predated her complaint to YouTube. So she made the caption look like it was Kate Peter versus Aidan Kearney. It was fake. What do you got to say about that, Cosgrove?
Aware of that because he or something of that nature. He admitted to having forged a document or something of that nature. Well, Mr. Kearney would be aware of that because he was involved in it. But there was no reason why the best of prosecutors, when somebody comes to them with information, they may check out the information, which is what was done here. People once looked at the broadcast that they were.
So Kate Peter came to them with information. Thanks for telling us everything. Kate Peter came to you or Tully with information, and all you did was maybe kind of sort of vet the information or just the clips, but you never vetted her as the source that you started to use for your not so confidential informant. Do you see what he's saying? He's like, all we had to do was vet the information. We didn't vet her. It's not our job. And this is what they're presenting to a grand jury. Everyone in Norfolk County right now who lives there should be very afraid. Should be very afraid because they will convene a sham grand jury. They will get someone who's a known scammer, liar, and forger of documents who has a personal beef with the guy you're trying to indict so badly that they spend their entire lives trying to destroy this person. And you don't even look into that at all. You don't even want to know. Anybody who did a 10-second Google search into this woman would know how much she hates Aidan Kearney and the things that she's done in the past to try and screw him. And that's wild. That's wild. And if the judge buys this argument, you should all be very afraid. Listen to this again.
Information, they may check out the information, but there was no reason having forged a document or something of that nature.
Something of that
Mr.
nature.
Kearney would be aware of that because he was involved in it. But there was no reason why the best of prosecutors, when somebody comes to them with information, they may check out the information, which is what was done here. People once looked at the broadcast that they were pointed to, why they would go back and screen for federal court cases to see if the witness had previously been involved in a federal court case, it's not a search warrant where you're trying to establish the veracity of the informant, and maybe you do some research in that case, although I think it would be rare that that kind of research would be done. So the suggestion that the Commonwealth knew or should have known that this witness was tainted in that respect, I think is somewhat absurd.
To the best of your knowledge, do any of the Peters materials, were any of the Peters materials presented to the grand jury?
I could barely hear that. So he said, to the best of your knowledge, were any of the Kate Peter materials presented to the grand jury? Yeah, all of them. That's how they got their information. But Cosgrove will probably be like, I don't know. Because Mello is the one who conducted the grand jury with Tully.
The Peters materials were presented to the grand jury in the sense that there were a couple of audio recordings that were obtained from Kate Peters, which Mr. Lieutenant Tully could not find checking independently, because the theory was that Mr. Kearney had taken them down and had replaced them with different videos in which he had intercut a warning that was not actually there originally, that the conversations were being recorded. One of those
This was the wiretap indictment, which didn't
yes.
happen.
Okay, just to tell you what they're talking about. Kate Peter alleged that Aidan Kearney had recorded he did record a conversation, I think, with Steve Scanlon. And Kate Peter provided them with an audio recording of that conversation. They presented that to the grand jury as him illegally wiretapping Stephen Scanlon, but they never asked the grand jury to indict on the wiretapping of Steve Scanlon. Do you see how improper that is? They're not looking for an indictment on that. They're just going to show it to them to show that, oh, he's illegally wiretapping people. And he also, he also intimidated the O'Keefes, or whatever he said earlier about the O'Keefes. They presented that as the very last thing to the grand jury, but they never asked the grand jury to indict on intimidation of the O'Keefes. They're just throwing a whole bunch of prejudicial shit in there and hoping that it's just going to sway the grand jury one way. And that's exactly maybe what happened. We'll never know. But none of this stuff should have been presented to them if they weren't looking to charge him with the wiretapping. Do you see how improper that is? Take it back just a little tiny bit. Thank you, Grant, because on Zoom, I wouldn't be able to do this. And also, they were prohibiting people from broadcasting the Zoom. So praise be to Grant Smith Ellis.
Fine checking independently, because the theory was that Mr. Kearney had taken them down and had replaced them with different videos.
Did he ever take down the video recording or the audio recording of Steve Scanlon? I don't think that he would ever take that down. Is he now not being truthful to the court? Tully couldn't find him, so he just was like, trust me, bro, with Kate Peter.
She had intercut a warning that was not actually there originally, that the conversations were being recorded. One of those
This was the wiretap indictment, which didn't
yes.
happen.
Right. So those are the only two. The rest of them, whatever was brought to Lieutenant Tully's attention, and I can't tell you the extent to which they were brought to attention by Kate Peters, or the extent to which they were brought to attention by the victims in this case, who are obviously not happy with some of Mr. Kearney's broadcasts about them, or by both. But in every single case, Mr. Tully's representation is that he himself went to the internet, looked up the broadcast, recorded it himself, or caused it to be recorded by somebody in the office. I have to say this predates me, but I have no reason to doubt that representation, and presented them to the grand jury. And I would point out to Your Honor, to this moment, there has been.
Wait, okay, so he's now saying that Tully went out and watched the presentations himself and recorded them himself, and that's what he presented to the grand jury. Does anybody believe that? Does anybody believe that? Because Ken Mello did open Kate Peters' clips. And in fact, he was such a boomer that he was like, oh, you need to help me. I can't open them. Wow. I want to hear that again. I have every reason to believe that Tully went and found these on his own and he recorded them. He's making shit up as he goes along. This whole entire system is based on trust me, bro.
I have to say this predates me, but I have no reason to doubt that representation. I have to say, or by both. But in every single Peters, or the extent to which they were brought to attention by the victims in this case, who are obviously not happy with some of Mr. Kearney's broadcasts about them.
Wait, so the victims in this case also sent you stuff and clips? Did he just say that too? Whether it was brought to our attention by Kate Peter, or the victims in this case. Okay, so they were sending you emails too with clips. Everyone's trying to help you. But he's like, but it predates me, so I really don't know. Now he's got plausible deniability because it wasn't him, it was Mello. And he never had anything, he never had Mello sign an affidavit. He just said, I'm going to speak to you in the voice of Ken Mello. And if he was here, this is what he would say. So everyone can have plausible deniability, and the court system is just a kangaroo. What's worse than a kangaroo court? I got to hear him say this again with a straight face because I'm blown away by this.
Was brought to Lieutenant Tully. The rest of them, whatever was brought to Lieutenant Tully's attention, and I can't tell you the extent to which they were brought to attention by Kate Peters, or the extent to which they were brought to attention by the victims in this case, who are obviously not happy with some of Mr. Kearney's broadcasts about them.
Where are those emails? Where are those emails between Tully and the Haas defendants and the Haas plaintiffs and the alleged victims in this case, including Elizabeth Proctor? Where are those communications between them and Tully and them and Mello? Oh, I see a whole new avenue of discovery here now, because now he's really telling us everything. I don't think Aidan's defense team knew that the Haas plaintiffs and Haas defendants were forwarding information along. I think they just thought it was Kate Peter. Tell me if you think I'm wrong.
Or by both. But in every single case, Mr. Tully's representation is that he himself went to the internet, looked up the broadcast, recorded it himself, or caused it to be recorded by somebody in the office. I have to say this predates me, but I have no reason to doubt that representation, and presented them to the grand jury. And I would point out to Your Honor, to this moment, there has been no representation that any portion of the videos that the Commonwealth showed, which we presented to the grand jury as things that Mr. Kearney himself had recorded and broadcast, were not genuine. There's only been this argument that, well, they were taken out of context, if they saw something else, the jury might have thought something different.
Was the grand jury did it? I should have noticed. Were the wiretap indictments noted, or were they withdrawn?
Oh, let's see how he spins this. He wants to know, were the wiretap indictments null prost, or were they withdrawn? Wait a second.
I should have noticed. Were the wiretap indictments noted, or were they withdrawn?
Noted or with, I don't know. I thought he said null prost or withdrawn, but it could have said noted or withdrawn. I don't think they ever intended to indict him on the wiretapping, but let's see how Cosgrove tries to spin this, or if he even knows.
We didn't proceed, well, on.
But they did not ask for a vote, actually, is a better way to put it.
Well, on the Gaetani wiretap indictments, those were issued, but that complaint was dismissed.
Not worried about this.
So that leaves us with the Scanlon presentation. And what happened was, after the presentation was made, an issue was raised, and mind of an issue was raised with the prosecutor as to whether, in fact, a Norfolk County grand jury would have jurisdiction. Mr. Scanlon, having been, I believe, in Suffolk County, at his end of the conversation, and I believe Mr. Kearney was not in Norfolk County at the time either.
No builder, or it was, you're right, you were right, no build or withdrawn. So you didn't know this going in, that a Norfolk County jury wouldn't have jurisdiction? Because Aidan wasn't in Norfolk when it happened, and neither was Scanlon, but you presented it to the grand jury anyway. Isn't that even more of a hoodwinking? Isn't that even more fraudulent? You absolutely 100% knew that going in. The only reason you put it in there was to prejudice Aidan, and it was completely biased. That's ridiculous.
So there was some thought that maybe, as I understand it, maybe Mr. Mello would ask Mr. Marcy to get himself-appointed as a special prosecutor in Suffolk County for the purpose of seeking an and drugging it. But it was never pursued. With that in mind, the Norfolk County grand jury just expired without anything further being done.
Okay, he's telling us everything. So you're saying that Mello, who was hired as a special prosecutor to prosecute Aidan Kearney because Michael Marcy has a conflict, was then discussing with Michael Marcy whether or not they should try and get Suffolk County to try and indict Aidan again with regard to the Scanlon wiretapping. So what you're telling us is that Mello and Marcy were absolutely in cahoots when he's supposed to be totally independent. Got it. Thank you. Thank you for that.
So nobody ever went in front of the grand jury and said, this is withdrawn, but at the same time, no true bill was proposed to the grand jury relative to this. Yeah.
Just never asked for a vote.
Never asked for a vote.
Any more do you want to tell me?
No, I'm content to rest on my memorandum. I'm not sure I have some questions.
Mr. Bedrow, I want to back to speakers because I'm struggling to understand exactly what your basis on Peter's evidence is. Is it the loss of exculpatory evidence? I don't know. You tell me, because again, the motion comes in as an Odell McCarthy sort of, and then it goes on for many, many paragraphs. It never really tells me much about why this is important. So, is it an Odell, or is it a Commonwealth versus Willie loss of exculpatory evidence? I gotta know.
We don't know what Peter evidence ended up before the grand jury because nobody seems to have it. What I can tell the court is she provided a copy of a Scanlon alleged illegally wiretap call.
Which isn't part of this indictment.
No, but to get to the point where they just said on the Scanlon evidence, we just never asked for a vote. What they never did is what every prosecutor should have done, which is instruct the grand jury, disregard that. They didn't do that. I mean, that kind of just slipped by in that exchange that was just had. You put forth uncharged crimes of wiretapping and actually tell the grand jury this is punishable by up to 5 years in prison for whatever reason. It doesn't matter. You choose because you think there's no jurisdiction or not. What Mello was obligated to do as the legal advisor to the grand jury with a duty of fair dealing, not to be an advocate, but a fair and honest broker, was to tell the grand jury, you must not consider any of that. You should not consider that evidence. You should not consider any possible penalty. So where did that come from her? We don't know. We also know that she sent evidence to Tully and I believe also Mello saying, I have taken clips from videos which show his intent in a folder named intent. We don't know what that
Let me
means.
try to separate this out. I'm trying to understand your argument. Very fairly. Okay? It doesn't sound like there's any argument here this loss of exculpatory evidence.
Correct.
All right, so we can take that off the table. Right?
Yes.
Say yes or no.
Yes.
All right, so I don't need to worry about that. So what I'm now left with is the argument that the information, the only information that we seem to have right now with regard to Peters is the Scanlon non-indictment, right? Does that seem about right?
Well, and sending clips from videos in some folder named intent to tell them. That is what.
Well, we don't know that any of that got in front of a grand jury.
We do not know if that's literally what he is.
Correct. So what we do know is that the Scanlon information got to the grand jury.
We believe so. I mean, I can't tell you if they took her version and found it
Well, we know
out.
there was testimony about that, or evidence about that.
There was testimony of that uncharged crime
So
that
now,
was left there.
I'm really trying to hone down your argument, something I can get my hands around. All right? Now, what we
He's asking you to drill down on why he should dismiss this case. And he's telling us that this is his favorite argument. He likes this argument about the Scanlon stuff because in addition to playing this wiretap and telling the grand jury that wiretapping is punishable by up to 5 years in prison and then never asking them to vote on it, I think Judge is telling us that he's what he thinks the best argument is. Drill down on it, Bettero. He will.
left with is the question of whether or not the grand jury was, under Brown, tainted by the inclusion of that evidence.
Yes.
It's a high standard, really difficult, given Judge DeBoer's findings already. Or whether or not Mello had an obligation to instruct the jury on the law about that now withdrawn or not pursued indictment. Does that summarize the argument?
It does, and Your Honor, I can't fathom a world in which a prosecutor.
I'm just trying to make sure you understand the argument. I don't need further argument on it. I'm just trying to figure out if that's the argument.
Of course, he should have instructed the grand jury to disregard prejudicial uncharged crimes, which could result in somebody going to prison. Yes.
But I still have to go back to the Brown issue of whether or not it affected the integrity of the grand jury.
You have to determine whether it affected the integrity and ultimately whether it mattered. And, in terms of, did it probably influence the grand jury, the Mayfield standard, something else the court should consider about whether any of this matters. In March of 2024, Mr. Mello took another shot at grand jury involving Mr. Kearney and Karen Reed for essentially.
But not this grand jury.
No, but.
All right, we don't need to go there.
Your Honor, if I can have 10 seconds of leeway, none of the misconduct occurred in that grand jury. And what happened? The same allegations, same type of evidence, and that case was no bill.
That's a whole different ball of wax.
The point is, could it have influence? We don't know.
I'm not going to guess about the grand jury presentment that I've never read, I've never seen, and involves a far different set of facts than this. All right? Whatever, I don't know the details of what happened or didn't happen between Mr. Kearney and Ms. Reed. I don't know, frankly, I don't care. Okay? What I care about is this grand jury. Okay? And much of that communication back and forth, allegedly with Reed, allegedly with Reed, it's all before me. I'm not going to draw an inference from that. I can't. You know that.
I'm not asking because the same videos.
It's just a kind of.
No, Judge, I'm not talking about anything other than it was the same video evidence and Tully talking about the same things and
I'm going to
admittedly.
guess there was a whole lot more to that grand jury.
Bettero's point is that, Judge, we don't know whether the Scanlon wiretapping stuff influenced this grand jury, but we do know that they tried it again without the Scanlon wiretapping evidence and all of the other same evidence. And that time they did not indict. So therefore, we can infer that the Scanlon wiretapping evidence absolutely influenced the first grand jury. Do you see?
Than these videos.
Not much. The same video evidence and Tully talking about the same things and
I'm going to
admittedly.
guess there was a whole lot more to that grand jury than these videos.
Not much.
Whatever. It's not what I'm not reviewing.
Understood.
I'm not reviewing it. I don't have access to it. So I can't draw a conclusion as to whether or not how it compares. So that's blatant.
But you believe everything that Cosgrove tells you. Okay, cool.
The last place I want to go down the road is
Understood.
figure out the Karen, any interaction with your client, Karen Reed. That's at no part of this trial. All right? Not fair to anybody. Okay? All right. Anything else you want to tell me about this?
One other just response to something Mr. Cosgrove said when the court was asking him. why not just play or give the grand jury the opportunity, if they so choose, to have the videos? And the response was, well, they could have asked.
I didn't put a lot of stock in that, so I wouldn't spend any time on that.
Whatever they don't know, and the last point, Your Honor, is why rename the videos? Why say it comes from the intent? Why offer the opinions? It's to put their finger on the scale and to say, we believe he did it, you should believe he did it, and that's improper for a prosecutor to do as a legal advisor to a grand jury.
Fair enough. All right, I'll take it under advisement. Sure.
I just want to point out that from Commonwealth's perspective, the whole Scanlon argument is waived because they had the grand jury minutes at the time that they brought the last motion, including.
The scandal argument, it limited to the idea that they should have instructed.
Right,
Okay.
right. The second point I want to make is the argument that they don't know what information came from Ms. Peters. I guess my response is, it doesn't matter. It doesn't matter that she has an animus against Mr. Kearney, that the two of them are oil and water. It doesn't matter if the Commonwealth got those videos from Jack the Ripper or whether the Commonwealth got them from St. Teresa. The question is
Jack the Ripper and St. Teresa have just entered the chat. It doesn't matter if we got that information from a woman who hates Aidan Kearney. It doesn't matter.
the video evidence authentic, and it is.
All right, tough on that.
He said it only matters if the video evidence is authentic, and it is. We don't know because a lot of those links are dead. Remember? We went through this motion. It took us 2 shows, something like 10 hours. I don't remember how many hours it took. We clicked on all the links. Many of the links that she sent were dead. They were taken down. They don't exist anymore. So who knows exactly what was in there? The answer is nobody. Except the grand jurors.
Next issue. Do we have the third party here?
Yes, Your Honor.
Yes.
All right. From the defense.
Okay. Seems that I think Diller is in the building. And Diller is in the building looking to try and get Aidan's phone extraction, I think, for the O'Keefes to use in their wrongful death lawsuit and or defamation lawsuit. Well, no, the O'Keefes don't have a defamation lawsuit. The O'Keefes want Aidan's phone extraction to use in their wrongful death case to show that Aidan and Karen were conspiring to promote a false narrative. I think Betterow, I don't know who's going to be up first. Let's see.
Yes, Your Honor.
Yes.
All right. From the defense, I didn't get a response or an opposition. Is there a response or opposition?
No opposition, Your Honor.
They're fine with releasing these matters?
Judge, we're, from our perspective, this is all out in the possession of the internet, if you will. And it seems like everybody has it and can look at it except Mr. Kearney. That's another issue for another day.
Well, we returned it to them. Did it not? That was the order that the Compel
I know,
asked me
okay,
to
hold
do.
on. Okay, hold on.
Yes, Your Honor, but it's there's all sorts of.
Okay, just a sec.
Okay, whoever's on the video, you need to shut down.
And further, Your Honor, Mr. Kearney provided Attorney Diller with all of these communications.
So this is not an issue. Because my intent, frankly, my first impression here is I want to protect Mr. Kearney's rights not to have these materials, investigatory materials released. But if you're okay with it, I'm not going to.
Well, Judge, I appreciate that, and if you're inclined to do that, I certainly would ask you to do it.
Well, that's why I asked you if you opposed it, and you said no, so.
But if that's your inclination, Your Honor, any layer of protection we appreciate. But unfortunately, if this is out on the internet, number one, he's given it to Mr. Diller as a pro se, non-party opponent.
So what do you need from Mr. Diller?
Well, there you go. So it looks like Aidan Kearney did comply with the subpoena served on him by the O'Keefes and did turn over whatever he had. But Bradel is like, listen, I'm not going to waste time and money opposing this because Aidan's entire phone extraction has been released to the internet by the same person, I think. Well, I don't know who did it, actually. I was going to say K. Peter, but I don't know if it was K. Peter. I don't know who did it, but it's out there on the internet. Somebody hacked into his computer and got it, I think, and so it's out there anyway, but Aidan turned it over, so why is Diller showing up? Does Diller still need it? Does Diller still want his 5 minutes of camera time? And it seems that the judge was actually going to say, I'm not going to give it to him. Interesting.
What do you need from me if you already have it?
I don't know that I have it. I know that I just got a link from Mr. Kearney.
Oh, here comes Diller. Diller's like, I don't know if I have it. I just know that I got a link from Mr. Kearney. Did you click on it? Did you download it? Or are you just showing up to court today to be a dick? What? We know that Chris Albert thinks that Michael Proctor is a dick because he was really afraid they were going to find that text message in his phone. Here's Diller. Come to your screen if you can.
I have it. I know that I just got a link from Mr. Kearney a couple days ago because I went into our case and also got a motion to compel, which was allowed. So I'm entitled to at least compare the two matters to see whether they are consistent and that it's comprehensive. I appreciate.
Why was this before Judge Gilday, not me?
It was before Judge Gilday and he issued an order. There's a separate issue, which is we've executed a protective order, and any of the materials that will be provided from this case to us will be protected. There's also been a Gilday order that there's no dissemination or discussion of any of the confidential information, so there will be no leaks of data into the world, and this case will come to judgment prior to the O'Keefe case. So we'd ask that we get access to those materials. We know that they are the authentic materials, and we request we'll execute the protective order, as will the other parties who do not object in the O'Keefe matter. We'll all execute the same confidentiality protective order, and will be used exclusively in that case.
For the record, let's get your name, sir.
Attorney Mark Diller on behalf of the O'Keefe family.
Okay. Any further, anybody want to be heard on this?
Yes. I don't have any objection to providing.
Okay, if you're not watching your screen now, this is Cosgrove speaking.
Mr. Diller with a copy of the same.
On the game team and on the part.
Number 12, out of court.
On the right.
Hold on, I gotta take it back.
11th, out of court.
Just jumped. Where was Diller?
Cross that bridge when we get to the just where it was. Mr. Brady, what do you think?
Sorry guys, it just jumped.
Agreement. And you want to work it out? That's fantastic. If you still need more time, you guys can reach an agreement.
Back to what's already in.
Where's Diller? Oh, come
My
Okay. Any further?
on. Wait, who's this guy? Hold on. We're a little bit behind.
because they had the.
Yes, we don't know.
I'm not.
Sorry guys, hold on.
These materials, investigatory materials released, but if you're okay with it, I'm not gonna.
We'll do it.
It matters to see whether they are consistent and that it's comprehensive.
These materials, investigatory materials released,
You're inclined to do
so
I know that I just got
So Diller's not trusting what it is that Aidan got him. That's pretty clear here. What Aidan gave him. And so he wants, I guess he wants his own copy.
order, and any of the materials that will be provided from this case,
And ironically, materials that I believe are already out there on the internet, ironically, have been released. Not by Mr. Kearney personally, but through someone who was associated with him, as I understand it. The problem that I'm dealing with is
This Judge Proctor protected.
is essentially found on Exhibit B to the motion to intervene, which is the order from Judge Sisitsky, which was entered in the Karen Reed case. That motion was brought by Mr. Bradle on behalf of Mr. Kearney, and Mr. Bradle, as I recall, wished to bring it with respect to both the Karen Reed case and with respect to this case. Judge Sisitsky announced at the outset that he was only there to deal with the Karen Reed case. He wasn't going to touch the Kearney case, but the language of the order prohibits all agents of the Commonwealth, which would seem to include me at the moment, Your Honor, from requires us to maintain the confidentiality, which is now essentially non-existent, not share, publish, disseminate, or otherwise disclose the data or any information concerning the data. So I may be partially to blame for this matter being before Your Honor this morning, because my position was, I'm happy to give it to you, but I don't want to get caught between an order on the criminal side telling me that I have to protect this information, not release it, not disclose it, and an order on the civil side saying, turn it over in response to the subpoena.
And this has already been produced by Mr. Kearney on his own.
That's my
correct.
understanding.
Yes, as a pro se, non-party deponent.
All right, I'll take that for advisement. Okay.
Thanks, Your Honor.
Okay, he took that under advisement too. People are saying, why does Diller have standing? Diller has standing because he made a motion to intervene. He made a motion to intervene specifically to get a copy of Aidan Kearney's phone extraction. And even though Aidan's given it to him, he doesn't trust that that's the whole thing. So he wants it another way. And it's out there on the internet, but I don't even think his defense team has it really. It's unclear at this point. Let's see what else they're going to discuss.
Hit 139, this was the issue of the items from the TNT. Anybody want to be heard on this?
Yes, I'd like to.
I allowed it provisionally, but issued an order saying it couldn't be disseminated.
Right. The only thing I would say, Your Honor, is reading paper 134, which was the impounded report from Mr. Verma. It looks like some of the work has been completed, and there are 2 instances where he's looking for guidance from the court. That's the very last item, Apple iPhone A1549, and Apple iPhone on the next page, where he says the extraction attempts failed and he would need permission from an order to request an attempt by a law enforcement agency. I'm not sure how long it would take to accomplish those things. I haven't had an opportunity since, thanks to Your Honor's allowing a motion. I've only had this now for a couple of days. I haven't had an opportunity to check with somebody with more sophistication than I in matters of electronics and extraction. Someone more sophisticated than I would probably be any 12-year-old to stop on the street. But I don't really understand what this would involve and how long it would take and what the expense would be. So I'd like a little time to look into that. But with respect to what's already been done, and it seems to be that they have for example, the next to last entry, Honorable Macy reviewed and marked item for privilege. Working on producing the potential privilege down with notations by Honorable Macy, which items are deemed privileged for defense production. This was dated March 25th of 2026. This tainting process has been very laborious, and I would really like to get the ball rolling on this, or rolling a little further before we are up against the trial.
How soon do you think, how long will it take you to get, to formulate your position for further steps?
I don't think it will take me long at all, Your Honor. A week.
Mr. Federer, Mr. Radel, what have you heard on any of this?
Judge, I don't object to a week, if council wants to.
You have the materials he has is released to you.
Yes,
The report.
yes.
Okay. So,
See, I wasn't even aware of that.
well, that was the order that I issued.
Oh, you mean this? But. Okay.
That was the order that I got, was to release that report.
Right. But the text of the report says that they have the data, Macy's reviewed it or has reviewed some of it. I would like some indication to the tainting that would like to get it.
I don't know what exactly is in play here. Mr. Brett,
Yes, Judge.
you work with Mr. Cosgrove.
Okay,
You
yes.
guys need to file a further motion to assist this process, to speed up. Just get it to me.
We would like
I'll
to
draft
receive it first.
something, show it to Mr. Bradle.
You guys can work.
We'd like to receive it first, though, Your Honor. I appreciate the Commonwealth referenced this in their submission, that to the extent that there is a privilege notations in here, we'd like to see it first,
Absolutely.
evaluate it.
Understood, I get that.
Okay,
All
thank
right, so look, get a report back to me 2 weeks from today, all right? And if you need a further court order to move the ball forward, we'd like to do that. I assume you guys will come up with some agreement on it, right?
Yeah, I don't think it'll be.
Yes, sir. I proposed to council that I'd just like to have it for, let's say, a week prior to the.
I'll give you 2 weeks to sort this out.
All right,
All right?
appreciate it.
And
Thank you.
I suspect you don't easily interfere with this.
I don't think so.
I understand you may be less than cooperative. Okay, last issue, which is the issue for disclosure on Proctor. Did you folks have some discussion on this? Yes.
You did, Your Honor. We're almost there. And I think we need court guidance on one disparate issue.
It's very wide right now. Far too wide. All right. I think I know where you can go.
I think we're not gonna make you go through the labor of looking at our stuff.
All right, tell you what. 2 weeks to give me a report on what you see on that. All right, if you guys can reach an agreement, that's fantastic. Whoa! All right, we're gonna close the Zoom now. That's it. Zoom is shut down.
This is why we can't have nice things, because people on the Zoom don't know how to shut up. Remember Free Billy Tibbetts? Free Billy Tibbetts? F Judge Cannoni? F you Bev? Remember that came out one time? Seems like they're in agreement somewhat on Proctor's phone extraction being released. So that's interesting. Let's hear that again.
I understand you may be less than cooperative. Okay, last issue, which is the issue for disclosure on Proctor. Did you folks have some
The issue for disclosure on Proctor. It seems that they're coming to some sort of an agreement.
discussion on this?
You did, Your Honor. We're almost there. And I think we need court guidance on one disparate issue.
It's very wide right now. Far too wide. All right. I think I know where you can go.
I think we're not gonna make you go through the labor of looking at our stuff.
All right, tell you what. 2 weeks to give me a report on what you see on that. All right, if you guys can reach an agreement, that's fantastic. Whoa! All right, we're gonna close the Zoom now. That's it. Zoom is shut down.
Goodbye.
If I may, Judge, the only issue we're disparate on is the scope of the protective order relative to whether Mr. Kearney can be shown and not shown. And we were proposing that it would be just case-related materials from the Proctor extraction we'd be entitled to show him, not provide copies, to show him case-related materials. And I think counsel has a little more of a specific issue. I think that's the only issue we're disparate on.
If you guys have an agreement and you want to work it out, that's fantastic. If you still need more time to have this discussion, you want to come see me even by Zoom, we can do that. If you guys have, again, if you guys reach an agreement, I'm not going to stand in the way. If you need further clarification after discussion, okay, tell me.
I was just hoping to gently push the Commonwealth today to put their position out, which we discussed prior to this hearing, and perhaps Your Honor can make the ruling. I think it's a pretty straightforward thing.
Tell me what you think I should know, Mr. President.
Essentially, I have folded my tent, so to speak, and have agreed to provide information to Mr. Bradel to the same degree that has been provided in other cases where there is Proctor discovered. And Mr. Bradel has agreed that essentially the same protective order will be issued, which essentially boils down to that the materials provided will be provided only for the use of counsel and may be shown to the client. The client may not receive copies of those materials.
Is there any restriction on the use of those materials by the client? I think that's probably what we're circling around here.
Yes. That's my concern, and it seems to me that to the extent that the information, there's really two potential pieces of information. One is case-specific information, anything Mr. Proctor may have said relating to the specific case and Mr. Kearney.
That's would almost be automatic.
Sure, I would have no problem with that being shown to Mr. Kearney. However, it seems to me the bias information which is, as I understand it, a pretty standard. It's really the same for all defendants. The stuff going back, whatever the comments that Mr. Proctor made about this person or that person that potentially could be used to impeach him if he is called as a witness and show bias that have nothing to do with Mr. Kearney in particular.
That's a bridge we'll cross when we come.
Yeah, he's an equal opportunity bigot. He hated everyone equally. Didn't matter if you were black, a woman, gay, Asian. He hates everybody. He's bigoted towards, he's an equal opportunity bigot is what I think Betterow called him. And it goes to his bias and his inherent bias and how he treats investigations in general. And there's a lot of things that he said about Aidan Kearney specifically, and it shouldn't be limited to just that. And even the judge just said, we'll cross that bridge when we come to it. Listen to that.
Impeach him if he is called as a witness and show bias that have nothing to do with Mr. Kearney in particular.
That's a bridge we'll cross when we come.
I don't wish to be shown. I would like to be restricted from showing to Mr. Kearney because I don't think that counsel needs his input if we come to trial to present a statement that Mr. Proctor made 12 years ago about a woman or minority or whatever. I think the likelihood is it's only going to leak out into the internet to the extent it hasn't already. It's possible.
Oh, so you're now accusing Aidan Kearney of if he's allowed to see these things, not touch them, but just see them, that he would leak them to the internet. You know, like Proctor having a panic attack, which came to him from a different source, and Proctor being admitted to inpatient mental health treatment in Florida to avoid his deposition. And that also came to him through a different source. He hasn't leaked anything. They're trying to say that he did, but he didn't, because we know about timestamps and shit like that. But Cosgrove is going to make that argument anyway, and hoping the judge will bite it and buy it. Bite on it and buy it. Bite. Because, you know, we can't trust Aidan Kearney, Your Honor. That's why we had to tell the grand jury all these things that we didn't even ask them to indict on, like the Scanlon wiretapping stuff, because he's a bad dude. Guess what? Proctor is a far worse dude than Aidan Kearney, and everyone should know about it. Rosemary Scapiccio got it all. Why shouldn't Aidan Kearney? Shouldn't all defendants be treated the same? All defendants that have been victimized by Michael Proctor, shouldn't every single one of them get all of it? Shouldn't the jury know about all of it? It hasn't been limited for Rosemary in several of her cases. Wasn't limited for Karen.
Embarrassment or whatever. And the likelihood is it's only going to leak out into the internet to the extent it hasn't already. Possible embarrassment.
You can start wrapping the seal on people who make silly comments, inappropriate comments, unacceptable comments. It's going to open up things that we just don't necessarily need to come down. We'll cross that bridge when we get to it. Just
It's all relevant.
Mr. Brady,
So
what do you think you can just right now?
this issue that the Commonwealth wants to sort of parse out is too vague to parse that out. I can't look at something and say, you know,
I'll give you 2 weeks.
it makes it adverse to the client, Your Honor, to have to
I'll give
withhold it.
you 2 weeks to confirm. If you guys haven't come to an agreement by that, call Mr. Donnelly.
Okay.
Come in and see me. It's a 15-minute hearing. It should not take us long.
Thank you.
All right, so we've got 2 weeks on the issue of the contained team issue, and 2 weeks on this issue too.
Thank you, Your Honor. And then there's also a housekeeping issue relative to the dates, Your Honor, for trial and motions in May. I think we wanted to propose to the court. I think we hammered this out before you came out, which is that we wanted to propose Friday, December 4th for motions in limine, Monday, December 7th for trial and jury selection.
Figuring out when's going to be the time to use decisions.
So I have another concern, Your Honor. I don't know that we need to resolve it today, but I want to put it on court's radar, which is, this is an Norfolk County case. Where is this trial going to be held?
Well, I'm here right now. Let's put it this way. Wherever it happens, it's going to be Norfolk County juries. Okay?
There's your answer. This is right now. This is in Suffolk Superior Court, which my understanding is it's downtown Boston. It's a pain in the ass to park. It's very expensive to park. It's very hard to get to for boots on the ground and for everyone involved, including the defendant. And the judge is like, well, I'm sitting here now, but even if the trial happens here in Suffolk Superior, we're getting a Norfolk County jury. It's not that convenient for the jury either. They'd have to be bussed. I don't know how long it takes to get there in rush hour traffic, but maybe you can tell me, from Norfolk County to Suffolk Superior. That's the, you know, it's a burden on the jurors too. Like, judge, you can't just go rent out a courtroom in Norfolk Superior, which is where exactly this should be. Same place where Karen Reed was acquitted and tried when they wanted to hang her like a witch.
That should satisfy any constitutional concerns.
I think that logistically, Plymouth Superior Court would be an excellent location.
Logistics, where it happens, is going to be a discussion which I'm going to have with other folks who are involved here.
I appreciate that. I just want to put it out.
Is it fair to say, Judge, that you'll know maybe in September when the next rotation comes through?
We'll have I'm in this room until the end of December.
Oh, okay.
So I'm assigned to Suffolk County
So you're
until
subject to
January
review.
of 2027. So the assumption is going to be with me, and the assumption is going to be in this room. But we're going to have to make arrangements because this is a Norfolk County case. It's entitled to Norfolk County jurors unless he waives them. And that would be my intention wherever this happens.
I'm going to discuss that with Mr. Kearney,
That it be tried in front of the Norfolk County jurors.
whether we waive it.
Well, Compel gets, I think, word on that as well. So,
I have one other issue that I'd like to raise with Mr. Mr. Bradle, I don't need to ambush him, but I do want to bring it to the attention of the court.
I don't mean to ambush him, but I'm going to ambush him. Did you hear that? Sounded like Bradle has to talk to Aidan about whether or not to waive a Norfolk County jury. That's what I heard. Okay, tell us how you're going to ambush him now, Cosgrove.
There has been, so far as I recall, and I don't think I've lost my memory to this extent yet, no motion to
That's debatable.
suppress with respect to the devices that were seized from Mr. Kearney pursuant to warrant. Some of them may not be visible, but we have at least the two cell phones which the search was conducted, and the fruits of that have been turned over to the defense. Defense has the motions. I don't want to get to a week before the day of the trial and be told that Your Honor needs to hear a motion to suppress.
Are there items on the cell phones you intend to use?
Oh, yes.
Folks need to have a discussion about this.
Well, I'm sure we will have a discussion about it in this ability. I'm just concerned about,
Mr.
There
Bradle.
may be an eliminate issue, Judge. We don't see any suppression issue.
All right, so there's no motion to suppress it. We'll deal with it as a motion to eliminate.
That's where we were going, Judge.
All right.
that's fine.
Here's what I suggest, folks. Somehow, the judiciary tells me I'm going to get a lot of motions to eliminate. So maybe we should go back another week on the motions.
I'm fine.
Or at least take it to November the 30th, which is Monday before we'll bring in the afternoon and deal with that. That gives us a full week to get decisions out and adjustments to be made in your trial strategy.
Judge, can we go? Can I just confer 1 second?
Cosgrove doesn't want to be surprised with a motion to suppress. Bradle said, I think it's going to be a motion in limine. They've learned how to use the mute. Oh, hot mic. Oh, they learned how to use the mute button. Why can't they learn how to use the mute all button on the Zoom? The three of them are convening in the corner. Betterow, Bradle, Cosgrove. Bradle talking to Aidan. Cosgrove moseying back to the
Your
bench.
Honor, we would like to avoid the Thanksgiving week. We're wondering if we could move it back to, say, the 19th or the 20th of November for motions and eliminate.
That's a Thursday and Friday. Maybe the 18th of November, it's a Wednesday. We do our afternoon list on Mondays and Wednesdays, so to the extent we can stick with that.
18th?
What
Is that okay? Yes, that's fine.
So, any other schedule issues?
Could we maybe file those, so agree to file them like a week prior?
That's fine. Those days is all I need.
So 11th, out-of-court filing, November 11th.
Fine by me? Okay, just one other matter.
That's Veterans Day.
10th, for what it's worth. Whatever the closest date to that is.
Go to 12th. Give me another day of work.
10th.
12th.
12th, sorry, 12th.
Okay, although the Zoom is now shut down, let me just send this message right now. The court is fine with Zoom. The court is perfectly happy to have the public observe and see the proceedings that are here today and going forward to observe electronically observe the proceedings. What the court is not going to tolerate is commentary over the court's audio about people's thoughts. Happened 3 times. 3 times is all I need. I'm going to reopen the Zoom for the next hearing. If it happens just once, I'm going to shut the Zoom off, and that will be it for Zoom going forward. This is not a participatory experience for anyone but the parties. The message, I'm sure, will get out to the various parties who like to listen and rebroadcast. Zoom is a privilege, not a right. You don't get to participate in the hearings. Okay, anything else we can do today?
Just a little bit of clarification, Judge, on the dates, so I want to see if I have this right. November 12th, out of court, motion to eliminate service. November 18th, motion to eliminate, and that's 2 p.m., Mr. Clerk?
2 p.m.
And then December 4th, is that still a date, or are we off the calendar? Off the
Let's
calendar.
see.
December 7th, trial.
December 7th. I'll let folks, we can be flexible. If you need to come back a second time, come back a second time. I'll make time for you when it needs to make time.
Thank you.
Okay,
And we may come back on the Proctor protective order in the next couple.
so the two outstanding matters, number one, motion to dismiss to decide. The other two issues, on the tape team and on the Proctor discovery, if you need further guidance from the court, let me know. Give you 2 weeks to try to sort it out. If you need to decide it, I'll let you decide. Anything else? Mr. Cosmo?
No, Your Honor.
Mr. Federer, Mr. Brady?
Very good, Your Honor. Thank you.
All right, thank you very much for your arguments today.
Matters are under advisement. The court set the following future court dates: November 18th, the final pre-trial hearing at 2 p.m. with a trial, or 2 weeks later on December 7th at 9 a.m.
Okay.
All rise.
God save us from the Commonwealth.
Court stays in a recess. Thank you.
God save us from the Commonwealth, everybody. Shout out to Grant Smith Ellis. Go over there, give him a like and a sub because he did the Lord's work and we didn't have to suffer through the Zoom, which eventually got cut off because the judge or the court, whoever's running the court Zoom, does not know how to mute everyone. They don't know how to mute all. And so people spoke through again. And maybe it's people doing it intentionally because they want the Zoom shut down. And the judge gave a strong warning about that. Strong warning about that he does not, if it happens again just once, next time where someone doesn't mute, he's going to shut it down forever because this is not a participatory procedure. People on the Zoom should not be commentating over the court's Zoom hearing. And he's absolutely 100% right. And that is why when I go on Zoom and I do broadcast the Zoom, which I did not do today because they told me not to, and I follow the rules, that is why I mute because I'm not having my voice coming through there because everyone will know it's me. All right. If you're just tuning in, let's do a short recap of what exactly happened today. It is now 10:51. Hearing started around 9, maybe a little bit after 9. So it was about 2 hours that they were in court today to specifically argue Aidan Kearney's motion to dismiss the mega motion for extreme governmental misconduct and for a tainted grand jury proceeding. And that was first up. Mark Betterow was on the hot seat. He was the first to argue. And the judge had a lot of questions for Mark Betterow. And Betterow started talking about all of the things that were improperly presented to the grand jury used to indict Aidan Kearney, all of the clips that were shown to the grand jury that were given to Tully and Mello by Kate Peter. And the judge said, but don't they have discretion to show what they want? And Betterow said, yeah, they have discretion to show what they want, but not prejudice. That the whole entire grand jury proceeding was deceptive, that the folder was labeled intent. And so that may have led the grand jury members to believe that this is his intent. All of the clips were renamed to make them look very biased against Mr. Kearney. They were not the show titles of Aidan. I've linked the playlist to the Kearney case below in this video if you want to go back and catch up on that. But it took us, I don't even know how many hours to go through that entire motion to dismiss and all of its hyperlinks. That's why we call it the mega motion, because of how long it is. He also said, the judge at one point said, they were talking about prejudice and whether there was any prejudice to Aidan Kearney because of this. And Bettero said absolutely. It was prejudiced. He said that the rolling, for example, like the rolling rally, all they showed was like 58 seconds of the rolling rally. They didn't show the whole entire thing. He also said that during the grand jury proceedings, Mello and Tully said the word intent something like 30 times during the grand jury proceeding, and that may have swayed the grand jury into returning with something like 16 indictments, and that Tully also had inaccurate video titles. And then the judge said, well, the grand jury is not really a fact finder, because that's what Bettero said. Like, they're the fact finder. They should have all the facts. And Belezos said, well, the jury's not really the grand jury's not really a fact finder. They're a gatekeeper. My head popped off. And then Bettero started talking about, but they put their finger on the scale by doing all of these things that were highly prejudicial to Aidan, and that there was no context for the rolling rally video, and that they showed all of this evidence to the grand jury about Aidan's recording of his conversation with Steve Scanlon, and they told the jury that it would be up to 5 years imprisonment on a wiretapping charge, and then they never even gave that charge to the grand jury to even try and have him indicted on that. So that was highly prejudicial. And then Cosgrove had a whole abada about that. Well, yeah, we presented it, but then, we were questioning whether or not we had jurisdiction because, neither of them live in Norfolk County. So no big whoop, no biggie. And it seems to me that Judge Belezos gave grand jurors a lot more credit than they're due by saying things like, they're very sophisticated grand jurors. They could say they're very sophisticated. We know that jurors, even basic jurors, don't understand things like probable cause and beyond a reasonable doubt. And so I have my doubts about that. But his main argument for that first part of the motion, Bettero's was that the grand jury process in and of itself was completely deceptive, and that they gave too much opinion testimony on his intent. Tully testified several times about this was Aidan's intent. This was Kearney's intent. His intent was this. His intent was that. And that's completely inappropriate because context is everything. And remember, that true bill was something like 16 felony counts of witness intimidation and picketing. Now, he talked a lot also about Judge Doolin's decision. Judge Doolin's decision on a motion to dismiss previously did dismiss, I think, 4 of the counts against Proctor. I think 2 against Proctor and 2 against Buchanan. You guys can tell me if I'm wrong about that. And he seemed to be saying, Belezos, well, like Doolin already ruled on this. Like, why do we need to hear this again? And Bettero said, because we now have this new information about these mislabeled clips and things like that. And then we went on to discuss. Oh, and then Bettero said, yeah, but Judge Doolin was misled. Judge Doolin was misled because we didn't have this other information before. Then they went on to talk about Kate Peter and her role in the grand jury proceedings, and how Kate Peter has a personal animus against Aidan Kearney, and so much so that she forged a federal complaint and submitted it. They didn't say, but we know where it went. It went to YouTube to try and get a copyright strike against Aidan, that she's got a lifelong mission to destroy this man. And the fact that she was in bed with the special prosecutor, Ken Mello, and Tully to try and coordinate a prosecution of Kearney is outrageous. It's biased. It's shoddy. It was never disclosed to us that Kate Peter was working with them. They have a shockingly close relationship with her. She forged documents and sent them to YouTube. She was actually directing Tully and giving him these clips that she labeled. And the judge even said, but Tully didn't open the clips. And Bettero was like, well, how do we know? We've never had an evidentiary hearing. It's just, trust me, bro, based on an affidavit. He says, we've never seen an affidavit from Mello. And I pointed out to you and reminded you that the papers that Cosgrove submitted at one point said, I am now going to, the next part of my motion is going to be in the voice of Special Prosecutor Ken Mello. I can't reach Ken Mello, But if Ken Mello were here, here's what he would say. And then we read that entire part of the motion in Ken Mello's voice, but he didn't sign off on it or draft it or sign an affidavit. And I think you can probably figure out the reasons for that. They've also never been called in to testify. He also said that the fact that they were trusting a dishonest person is mind-blowing. K. Peter hates Aidan Kearney, and that many of those links that were never opened allegedly by Tully are now dead. Nobody can access them. And then Cosgrove got up and said, where's the beef? Where's the beef? Where's the beef? Peter Murphy is here. Peter Murphy was with Canton PD for over 30 years. Everyone loves Peter Murphy. We love Peter Murphy. And Peter Murphy says, this county and state need to charge them. This county and state should be charged with RICO. I think that's what you're trying to say. The feds should charge them with RICO. A lot of people have likened this to organized crime. It's been going on for decades. Many of you know this because you live there. All the way back to 1692 with the Salem witch trials. Where's the beef? He said that, he likened it to, people watch mainstream media and the grand jury is very sophisticated. The people on the grand jury are very sophisticated, and they know that when they watch mainstream media and they hear a President Trump clip, that they're smart enough to know that that was just a snippet. And he said, we would have shown them the whole entire videos of Aidan Kearney, but they were really long and they never asked. They never asked to see the whole video. My head has popped off. I think it's in Canada right now. Talking about Tully and Kate Peter, there would be no reason to find out that she forged a document that, when we're sent information by people, including not just Kate Peter, but the witnesses in this case. So we now know that the witnesses in this case, or the victims, and I use air quotes loosely here, have also provided information to Mello and Tully. Did we know that? Because I think that's all discoverable now. We checked out the information that she sent, but we didn't do a deep dive into Kate Peter. Why should we? Why would we? How would we even find that out? We're not obligated to do that. That is also mind-blowing. And I think one of the most damning things that Cosgrove said, he admits that they did show, and then they went into the wiretapping of Scanlon, and that those recordings were sent to them, those audio recordings, by Kate Peter. And also he did admit that the victims or Haas defendants or Haas plaintiffs, however you want to refer to them, did provide information to them. And then the judge was very interested to know what they did with the wiretapping charges. Were they no billed or were they withdrawn? And Cosgrove was just like, yeah, we didn't ask them to vote on it because we thought we might have a jurisdictional issue. That might be the way out of this. That might be the way out. It seemed to me that was something that the judge was more interested in than the other arguments about the video clips. And then he did say that Ken Mello went to Morrissey to see if they should go to another county maybe and pursue charges for the Scanlon wiretaps, but I guess they decided not to. And he also, in saying that to us, revealed that once again, Mello and Morrissey are in cahoots, and they're not supposed to be, because the reason Mello was hired, and he's now been replaced by the body of Cosgrove, is because Michael Morrissey has a conflict, and they're not supposed to be communicating and strategizing together. But apparently the rules don't really apply to them. Better then got up and said that one of his main arguments is that, yeah, they presented all of this evidence to the grand jury about Scanlon, but they never told the grand jury to disregard it. And they were required to do that. And so, of course, the grand jury members considered it when handing down these 16 indictments because they were never told to disregard it. And in fact, Tully even said, or whoever it was, Mello said, oh, yes, and wiretapping is punishable by up to 5 years in prison. They heard the recording and they thought, oh, well, he's guilty of that, even though we don't have to decide whether or not to indict him on that. So he's probably guilty of all this stuff, other stuff too. there you go. And he pointed out once again, prosecutors, when conducting a grand jury, have the duty of fair dealing. And it is clear that fair dealing was not part of this grand jury proceeding against my client. It was tainted by the evidence. They didn't tell the grand jury to disregard it. And in fact, Your Honor, in March of 2024, they convened another grand jury. They had all the same exact evidence except the Scanlon wiretapping. And they tried to indict Karen Reed and Aidan Kearney, and the grand jury did not indict. And Belezos was like, I don't care. I don't care. And he's like, but I'm just pointing it out that without the Scanlon wiretapping, there was no true bill. But Belezos didn't really want to hear it. And then Belezos said, well, as far as the the argument that the grand jury could have asked to see the full videos, and Belezos just cut him off and he said, don't even spend time on that. Don't even spend time on that. So I guess, I don't know. I don't know what to think. I don't know what to guess. I won't really guess, but it seems like he didn't really think that that was a strong argument on behalf of Cosgrove. And again, Mark Bettero's main point is that Tully and Mello had their finger on the scale during the grand jury proceedings. They're not supposed to do that. And that they gave way too much improper opinion in front of the grand jury about his intent. Cosgrove is trying to say that the Scanlon argument was waived because they didn't bring it in their first motion to dismiss. And the judge took it under advisement. Then the motion to intervene by Mark Diller in the O'Keefe versus Reed matter. They want Kearney's phone extraction. Bradel said, we don't oppose it because it's out there on the internet, and we already gave it to him, or Aidan already gave it to them, and they should have it. And Diller got up and said he still wants it anyway. Then there was some argument on the taint team issue, and somebody can remind me, because there's been 7 million motions. Are they still talking about the taint team on Aidan's devices, his other devices? I think that's what they're talking about. They've had his phones since October of 2023, when they arrested him at his kid's bus stop and seized all of his devices in his house that they could find. And apparently they're still dicking around with a taint team on that. But Stephen Verino, who seems to be the guy who's hired in every single case to be the taint team guy, he's also going to testify in Lindsay Clancy's case. He's on the witness list. That they have an impounded affidavit from him, and that they're trying to work on parameters to exchange or disclose that information. So remember, they were looking for attorney-client communications and any other privileged communications that could have been contained in his other devices. And they did use a special master, and I think the special master was Stephen Verino, as I recall. Now, this has nothing to do with Karen's phones, because Karen's phones are not involved in this case at all. Cosplaying, somebody said, which I thought was fantastic. Then they're arguing, then the next motion to be argued was the Proctor materials and how much they should be able to get and how they're going to be able to get them and what they should be able to see and not see. And they're trying to reach an agreement on that, Proctor's total phone extraction. And Cosgrove intimated, or pretty much outright said, that, Kearney should be able to look at it, but they shouldn't give him a copy because, there's been leaks. Cosgrove also seems to think that that Kearney's team should only get Proctor messages that are directly relevant to Aidan's case. And as you know, I completely disagree with that. That he shouldn't get stuff on general bias, just the stuff that has to do with him specifically. But we know, because it's been redacted in the motions, that Michael Proctor and Yuri Buchanan and others, including I think maybe the Haas defendants, were all on some chain text message threads together talking about how why don't you just arrest him? Just arrest him already. We'll figure the rest of the case out later. Portions of that are still redacted, but why should they be? Because Rosemary Scapiccio and Karen Reed have both been allowed to use them in their recent pleadings. So they're trying to reach an agreement on that. 2 weeks. They're going to get 2 weeks to reach an agreement on the Proctor messages and the Proctor disclosure and the taint team issues. And motions in limine are to be filed by my notes are chicken scratch. Filed by, I think they've landed on November 12th Final pretrial hearing, November 18th, trial, December 7th. And then we got the big warning about the Zoom. Judge said, I'm here in Suffolk County until end of December or January of 2027. So pretty sure the trial is going to be here and we're going to have to bus a jury in from Norfolk County. Seems to be very much inconvenient for everyone involved. But this was specially assigned to Judge Belezos. And I think Belezos did say at the beginning of this case on one of the Zooms that we watched that he did disclose, listen, I don't know if he's from Canton or grew up in Canton and he's known in Cosgrove for a really long time. Is that okay with everyone? And everyone said, that's okay with us, Judge. Oh, please. And so, no, nothing was ruled from the bench. Everything was taken under advisement. How long will it take? I don't know. Carrie Cherry, thanks for your 10. Good morning. Obsessed with the whip tallow. Oh, I love it too. Thank you. Listen, I love to share secrets. It's the best. I love it. It's changed my skin. And they don't sponsor me. Highgate June says today's my birthday, which I share with my daughter. Reen, I'm sorry if I'm pronouncing that wrong. Happy birthday to you and your daughter. Thank you so very much, June, for your 20. Says, let's make it a Manic Monday and have some fun. Let's do it. Lola, the good dog, says, hi, Mel, or a good early morning from LA. I love LA. This judge makes me nervous. He's very unpredictable, but as always, oh, thank you for your compliment. I appreciate you. Matt McCabe's broken caps lock. Oh, that's well done on the username there. Thanks for your 10. Regarding Kevin Reddington and Lindsay Clancy's case, is it not a conflict with him having been Jen McCabe's lawyer and the 227 search and then Lindsay Clancy's phone data? McCabe, he was siding with Celebrite and now he's against them. No, it's not a conflict for him. He can argue on his client's behalf, whatever position he deems to be more beneficial to his client. So yeah, no, that's not what a conflict is. He can change his opinion based on his case. Nothing that he said in Jennifer McCabe's case was evidence, right? His arguments are not evidence. Great question, though. Thanks for your 10. Ginger Fried Kevro said, as someone who was kicked off a grand jury, I can also say the people who are on it do exactly what the prosecutors ask so they can leave ASAP. Thank you. See, there's a little insight for you guys. Sheep Teeth said, judges say it's not for you, lawyers, to decide what discovery is relevant. It's not up to this judge to decide what judges say. It's not for you, the lawyers, to decide what discovery is relevant. It's not up to the judge to decide what the jury understands. Thank you for your 5. Julie, thanks for 10, says Mark is fighting hard, but this is so frustrating. Every hearing is a shit show. You're right. It is. This is the way court works. I can't tell you that it's incredibly unusual. It's what it is. Thank you, Joanne, for your Cash App. She said, can Cosgrove argue in 30 minutes? To me, Cosgrove didn't really have much of a leg to stand on. He really didn't have a lot to say because he doesn't have a very strong argument, in my opinion. I mean, if you think he's got a strong argument, anyone out there, of course, let me know. I'll listen to you. But I didn't see it. It was a whole lot of abra. Alice says, I'm sorry, can he only have one basis for dismissal? No, he had a couple. But the judge has the papers. The papers are extensive. And I think during oral argument, he had specific questions that he wanted him to drill down on and to focus on. Thanks, Alice 35. The Kiwi Crypt Keeper says, all the way from New Zealand, why are we not surprised by this judge's behavior? But does this not open a path for an appeal if it goes against Turtleboy? I don't think that a decision on a motion to dismiss is appealable. They would have to wait until after a conviction. They're very, very slim thing. Very few things you can argue that you can appeal. Pre-trial, interlocutory appeals, they're called. There's only certain things that you can appeal. And I do not think a motion to dismiss would be money well spent if it's denied, which it probably will be. If it is granted, I will be very surprised because they're rarely granted. How does Grant broadcast without Zoom? He's in the courtroom with a camera. He got permission from the court. He filed a motion and he brought his equipment, and that's how he broadcast. A reminder to go over, give him a like and a sub and a view on today's video that he live streamed from the courtroom for us and everyone, and sub up. I think when I first shouted him out, he had like 8,000 subscribers. I want to say, I said, let's get him over 10,000. You guys did that like in the matter of a day. And I think now it's almost doubled since then. So I'm glad he's out there doing the Lord's work, and a lot of really good war coverage as well, if you're interested in that stuff. He will be on here tomorrow at noon. I got to make a whole thumbnail and put it up, which I haven't done yet. So thank you for that question, Kiwi Crypt Keeper. I think the judge wants this case to go to a jury, and I think he's been saying that all along, right? Yeah, Grant does have a media pass, and that's why he's able to make the motion. Exactly. Amory says, word salad, this man should have stayed in retirement. He was a Norfolk County judge. Cosgrove was, and he was retired. He came out of retirement specifically, I think, for this case to be the special prosecutor to help Ken Mello. And where is Ken Mello? Is there proof of life? We do know that Ken Mello threatened to stab a nurse recently in a Fall River hospital. Whatever happened to that, I don't know. Thank you, Anna Marie. And Lemonade is outraged, aren't we all? We have an emoji for that. My earrings came from Cancun. There's a local artisan in Cancun, and that makes these Dave Matthews earrings every year, different versions. That's right. Yellow Lead Betero says at this point, Cosgrove could just get up there and sing the ABCs as his argument, and the judge would accept it as some kind of fact. He's just out to get Turtleboy. I feel like everyone is, you know, they don't want the truth coming out, because when the truth comes out, it's going to be a big problem for a lot of people. I'm not saying this judge has anything to do with it, but it goes far deeper than the Karen Reed case. And Grant Smith Ellis is going to join us tomorrow to give us his thoughts on that, because he's done the research. He's got a photographic memory, and he's wicked smart. He's at 14.4. Jill says, at my favorite beach today on Cape Cod, no place I'd rather be watching with Ollie. Oh, have a nice beach day, Jill. Thanks for your 20. Texas Katie did says, why do I suddenly get the feeling we're watching the Salem witch trials instead of screaming witch? They're saying he did bad stuff. Yeah, he hurt my feelings. That is how broad the witness intimidation statute is. He hurt my feelings. My feelings have been hurt. I'm afraid. Charge him with a felony. And certain people in that town have a bat phone line directly to Michael Morrissey. We know it because we've seen the hostage video. Nick Gross says, so basically their entire argument is Aidan is good with tech. Thanks, Nick, for your 5. Victor Man says, what's the relationship between the McCabe's and the Alberts or Cosgrove with this judge? Don't know. Kelly, thanks for your 5. Kelly says, we need a Velcro sneaker emoji with triple dip written on the Velcro strips. Just saying, love you, Mel. Thanks, really do. Oh, thank you so much, Kelly. Kyle says, I love your stream so much. I'm usually so outraged that I'm blinded to points. You resolve the forest trees problem I have. Love you with all my heart. Thank you. My preferred method of doing it is while it's happening, because recaps are hard. It's hard to remember everything. So I stop and I explain it while it's happening. Otherwise, it would take me a long time to recap it. So I did just a little mini recap, and I'm glad you like it. To make an account says, I hope that Aidan sues Tully and Company when he's acquitted. I would put money on it. I would put money on it. Sweet Southern Honey said the grand jury was tainted by the prejudicial extra information provided in that hearing. I think so. I mean, there's no way that you can ever really know, because you can't call them back and ask them. But I think we can use our context clues based on what happened at the next grand jury, right? Oh, please. I know it is wild that you can go to prison for hurting somebody's feelings. It really is. Somebody once said, I think in this specific case, that a better place for this would be civil court. And now Aidan and Karen have been sued for defamation. At Ford Dread, thanks for your 5. Why are they still protecting Proctor? They're hiding so much disgusting stuff. Air all his dirty laundry out. They're scared to have several people walk free. Kind of sounds like that, right? Zoe, that you said this earlier. Now he's claiming they turned over results from searching 2 additional cell phones. Yeah, there were Aidan's. I think they collected a lot of old phones that he had in his closet, right? Has nothing to do with Karen. Nothing to do with Karen. Karen's phones aren't relevant for Aidan's witness intimidation charges. Thank you. So that's what it is. It's the other phones that they seized in October of 2023. My Crazy Life says, how many millions of dollars has or will the Commonwealth spend revolving around a crime that never happened? John O'Keefe was not hit by a vehicle. Full stop. Ridiculous. Agreed. I will link the tallow to the stream. I think maybe I didn't. I will. I'll link it. You can find it. And it's also in my Amazon list, which is in the show notes below this video. No, I'm not going to swipe his stream. If you want to go watch him, go watch him. Ashway says, I've been here for 9 months. I love you with all my heart. I love you too. Fallen Hero has gifted a membership. Thank you so very much. Unholy Saint says, first time I caught a live. I love it here. Thank you for your 5. D.H. Reed says, interesting how a jury isn't apt enough to find Karen guilty, but then so brilliant as to infer what's in the evidence, not provided or ask for it. Yeah, I agree. Bowie the Lab says, I was on a grand jury for 18 months. The judge's assumption about grand jury's intelligence couldn't be further from the truth. Right. Right. And you were there for 18 months. He's like, oh, we couldn't have them watch every single video because, it would take a long time. Grand juries usually do take a long time when they're not just quickly trying to indict someone that they hate and that they just want to shut up. Right? Karen Sutter says, I was sitting in the courtroom listening. So glad I was there, but I couldn't wait to hear your commentary, Melanie. Where's the beef? I couldn't believe those words came out of his mouth. It looks like a very small courtroom. Karen, is it a really small courtroom? I mean, from what we could see of it, from where Grant was. Glam Sue's loves it also. Loves the tallow. She says the lavender is awesome for migraine sufferers. I have an hour plus to catch up on. Happy Monday, Suze. Happy Monday. Blessed Mom in Texas says, praying for Turtleboy. I'll be in Massachusetts if it goes to trial. Side note, oh, love you and you look amazing. I'm 46 and going through menopause and want to try the tallow. Is it worth it? It's only for $30. It's 100% worth it. 100%. Check the Amazon link in the show notes below the video. Says my Amazon storefront, and it's right there underneath the show notes of this video. Everything in there. The cards that I use are in there. All my favorite things are in there for you to buy for you, not for you to buy for me. Love my flip-flop says it's really hard to believe this is real life. I know. That's why we have Twilight Zone emojis for this. Twilight Zone emojis. We've got them. Susan's back. Says, FYI, I'm on baby watch. You having a baby? No. My first grandniece, and yes, I have. And I went to Cancun, onesie for her. Oh, that's awesome. Mom just butt dialed me and I jumped. Butt dials. That's hilarious. All the links are in the show notes below the video. Just close your chat out if you're on your phone and then click on the show notes, which are extensive. And if you scroll down there, it says donate to Turtleboy's Defense Fund, which is something I also recommend you do. And then there's a merch link. And then Amazon storefront is right below that. Amazon storefront. Just click on there. You'll find it. Moby, Massachusetts says, did I read correctly that the prosecutor is the only one present with the grand jurors? Yes. Yes. There's no defense. There's no defense attorney. There's no judge. It is the prosecutor and the grand jurors. And whatever it is, the prosecutor wants to present as evidence, whatever he wants to show them as videos, whatever witnesses he wants to call. The defendant is not a part of that proceeding. The defense attorney is not a part of that proceeding. And oftentimes, most times, the defendant doesn't even know the grand jury process is happening. And so, yes, it is a totally one-sided procedure. Hi, Sherilyn. My tallow melted in my purse. Time for more. Oh, dude, you can't leave it like in a hot place because it will. It will melt. Thank you for being here for 22 months. Do motions to dismiss ever get granted? Sometimes they do. Got dismissed for Aaron Spencer. All of his charges were dismissed based on the prosecution and their lack of chain of custody, and they lost some evidence. And all of Aaron Spencer's murder charges were dismissed outright. It was a glorious day in Arkansas when that happened. Sometimes it happens. Massachusetts, it doesn't seem to happen. Angela, very interesting. Thanks for your Venmo. Says no judge in the Commonwealth will go against Cosgrove out of respect for him. Remember, he was a judge in Norfolk County. Interesting. Laura, in Yiddish, the word for this is verklempt. Yes, I know. I'm so choked up that if I wasn't so angry, I'd cry. Aidan can't get a fair hearing. Thank you very much. Betsy, thank you for your Venmos. I am outraged. Susanna, the kindergarten plenary authority thanks you for covering this today. Kindergarten is the way that Courtney Proctor pronounces kindergarten, which is wild. Elaine, thank you very much for your very generous Venmo. Says happy Monday, free Turtleboy. Amazing. War Pigs Crawling says Cosgrove getting double our prosecution tax dollars all this time to do nothing independent. He's basically stealing and lying. Even says he talks to the prosecutors in court. It's a joke. We're paying money for it. You're paying money for it. The real Paul Revere is here. The real Paul Revere says this isn't just a hearing for Aidan. It's for all of us. And you're right. Because listen, if the witness intimidation statute can be weaponized against a guy like him, who's a reporter, who's just asking questions and trying to get to the truth of what happened in the murder of John O'Keefe, because John O'Keefe was not hit by a car and a car did not hit John O'Keefe. And he's got opinions and he's trying to draw attention and get the government to pay attention that there should have been some other suspects and some other people might possibly be covering up things and hiding things. The fact that he hurt some people's feelings by asking them questions, and that he can be prosecuted with felonies for that, facing literally up to 100 years. It's up maybe down to 90 something years in prison for it, is just a wild thing. It's wild. And it shouldn't happen to him, and it shouldn't happen to you. But if they can do it to him, they can do it to you. Jen, thank you for 5 matcha lattes. Says, I love when I can catch a live. Thanks so much for all you do. Thank you for watching the replay on the videos. The videos that we did. We're still not done. If you guys want to do that today, we can. We can watch Julie Albert. You want to watch Julie Albert after this? It has to be a separate stream, though, because I need a little break. I got to do something with my voice. Let me know if you're interested in watching Julie Albert's Rule 14 MSP interview. Maybe around 12:30 or so. What do you think? Sidwell says, this is 100% selective prosecution, and they just look the other way. They just look the other way. It's like, whatever. No big whoop. No biggie. How come the other people that are knocking on doors right now over there in Massachusetts, knocking on doors, Boston Globe, how come they're not getting witness intimidation charges? They just hate Aidan. And they're using a woman like Kate Peter, who hates Aidan, to try and incarcerate Aidan, because nobody's got a bigger beef. You want to talk about where's the beef? Nobody's got a bigger beef against Aidan than Kate Peter. Am I right or am I right? You know. Keep talking amongst yourselves while I just set up this next stream so I can teleport you over there. She's telling us everything. Like, the more we learn from these interviews, the scarier it's getting. Am I right? We can talk about all of that as we get over to the next stream. So hold on for 1 second. All right, I'll set that for 12:30. We'll take an hour lunch break. How's that? Hold on. Oh, this is so stupid. I don't know. StreamYard has started this new thing where now my thumbnails are too big. That's just not a real thing. right, let's just get rid of it. But now I can't get rid of it. Oh, for the love of traveling. You're going to have to give me a minute to set this up. Everyone needs a gin and tonic right now. No judgment. No judgment at all. Thoughts, questions, comments, concerns before we wrap this one and head over to the other one. It's just going to kind of be a blank one right now because that's all I got. Hold on. I can't walk and talk at the same time, which is why this is taking a minute. Keep talking. If you were watching what Aidan Kearney had to say, what did he say after the hearing? Was he in good spirits or not good spirits? I'm going to teleport you over there so you don't even have to do anything other than buckle your seatbelt. Didn't sound to me like it was going to go his way, but maybe, just maybe, the fact that they did show that Scanlon stuff, even though they knew that they couldn't prosecute it, and then never even asked for them to return a true bill, maybe that's the way out for the judge and everyone. I don't know why it's not. Hold on. Oh my God, that took forever. Okay, we're going to redirect. We have the ability. We have the capability. We're doing it. We're coming back at 12:30. Thank you all for hanging out with me for this 2-hour and 45-minute hearing and recap. Thank you, Jennifer, who says, how can they present false evidence to a grand jury and this judge not see that? I'm confused. Well, I guess nobody really knows what they showed because, he thinks the grand jury is smart enough to know that they're just snippets, but they're wild. Dina says, out of court at Regina Pizza, free Turtleboy. Thanks, Dina. Gen XIM says, bring on the trial and let all of them get up and testify under oath. Then a jury can set him free and they can suck on that. Yeah. I think a trial is where it's headed. I really do. I thought that Bettero had a lot of good arguments, but just the vibe that I got from the judge was that he just wasn't buying it. I don't know. What do you think? Leave your thoughts in the comments below. Leave your thoughts in the comments below. And also, I will see you at 12:30. We're going to take a look in an hour at Julie Albert's MSP interview where she tells us more. And you can decide if you think that her behavior is suspicious. Don't be suspicious. Janet, thank you for your Venmo. Says, thanks, Mel. I appreciate you guys so much. All right. I am going to see you in 1 hour from now. I'm going to teleport you over there right now. Smash the like button on your way out. Smash the like button again on the way into the next stream. And let's do a little Julie Albert. Julie Albert was Courtney Proctor's nanny for 9 years. 9 years. And they didn't think there was a close relationship between the Proctors and Chris and Julie Albert, parents of Colin Albert. Oh, it's going to be good. Buckle your seatbelts. I'll see you over there in 1 hour. Peace. You might have to wait a minute for the teleportation. There you go.